morning, sir. Can you tell me your name?
My name's Dan Lu.
Mr. Liu, you're here in case 2021 CF 15494AO on a charge of kidnapping and attempted sexual battery of a person 12 years or older. The judge signed your warrant has already found probable cause for your arrest. And Mr. Longwell, you can put your name on the record.
Yes, my name is Mark Longwell of Longwell Lawyers. I'm here on behalf of Mr. Liu.
All right. All right. I think Judge Gibson tried to give me a rundown of yesterday.
I will do my best.
Right.
We were here for a first appearance yesterday, and I still have not actually had the benefit of seeing the arrest affidavit or the warrant for the arrest affidavit. The state, for whatever reason, didn't want to let me see it yesterday. They felt like Marcy's law precluded that, I believe. That's the face I think I made too. But regardless, it was partially read to me by the court. Probable cause obviously isn't an issue for today because it's a signed warrant by a judge. The only issue yesterday was I was asking for a determination of bond. The court indicated it would be so inclined to use the discretion despite the fact that that one of the counts is a first-degree felony punishable by life, but there was apparently an expressed concern about whether the alleged victim had been notified.
Okay.
And so I suggested we reset it till today to ensure that the state had ample opportunity to notify the alleged victim, and then the court could make a full determination with any alleged victim input.
All right, so I believe the kidnapping is a life felony, and is the state where you asking that Mr. Liu be held no bond?
Yes, Your Honor.
And did we have a chance to reach out to the alleged victim in this case?
We did, Your Honor, and she said that she did not want to attend.
Okay. I'm trying to think about, was inside the affidavit,
I know this much about what was
I
written.
guess the issue is, and I'm trying to think of the Marcy's Law question. I think at some point in the affidavit, it does list her address of where the beginning of this incident did take place, which has always been a question for me. Like, I mean, the courts haven't really said yes or no as to that question, like where obviously her address would be confidential if, for discovery purposes, things like that, but if the crime happened at her house, I don't know how we can then say it's not discoverable at that point, because.
And we had a pretty interesting conversation yesterday about the boundaries between an alleged victim's rights under Marcy's Law and an accused's rights to understand what their charges are and the basis of their charges. Regardless, the court was kind enough to read to me substantially the affidavit, and because probable cause wasn't the primary issue, really, we were just kind of skipped past that and started talking about bond issues. Okay. And there was a discussion about the fact that whether he's entitled or needs an Arthur hearing, and I understand all that, but I was regardless asking the court to exercise discretion in granting a bond. And while the court, after a discussion on the facts and his ties to the community and his lack of prior convictions for any kind of serious criminal history, the court expressed some inclination to be inclined to grant it, but reserved that pending some victim notification and possible input. That's what I think I'm stating properly.
All right. Well, so in this court, fall into the 3rd DCA's reading of our Florida Constitution, and I just don't think, for the obvious setting that we're in right now, that Arthur hearings are the best place for them. So, and it should happen in a reasonable time. I wish I could tell you what division this is in. And, sorry, so it's Judge LeBlanc. All right, so I had a note from yesterday, minute from yesterday, Judge LeBlanc, in his division 22, at this time, I want to hold him at no bond at this time, and that he got a reasonable opportunity to have that Arthur hearing in front of Judge LeBlanc on a state bond in count 2, the amount of $10,000. Condition of the bond: no contact with the victim, no return to the scene of the location, You may not possess any weapons or firearms. The weapons or firearms you have need to be turned over to law enforcement within 24 hours of your release from this case, if you are released. And you have Mr. Longwell representing you in this case. He's a very experienced attorney, so you should lean on his understanding and experience in these matters. And he can get you in front of Judge LeBlanc as soon as possible, and you can have that full-blown Arthur hearing, and we'll see if Judge LeBlanc feels that either if evidence presumption is great, and even if so, that he will exercise his discretion in releasing you in this case.
And Your Honor, I understand your ruling and respect your ruling. I just want to clarify one request I had beyond an Arthur hearing. So to be clear, I'm not requesting this court to conduct an Arthur hearing. And I understand his right to go in front of Judge LeBlanc and have that. But what I am requesting is if the court, regardless of Arthur, even if we assume for purposes of today that he's not entitled to a bond, the court certainly under the case law has discretion to issue a bond, which is one of the purposes of a first appearance. And that's what I was asking the court to do, is use that discretion based upon the alleged facts and the, from what I understood from yesterday, there are uncorroborated facts and his ties to the community. He lives here, he works here. And I'm happy to put that testimony on. If you would be so inclined to exercise that discretion, I can give you that testimony. If you'd rather wait for the Arthur hearing, I understand.
Well, Judge Longwell, it's not really that. We amended our Constitution to add that pretrial detention section in Article 1. Then we subsequently made no changes anywhere else really, as far as 907.0, like 904, so 907.041, which is our pretrial detention statute. We made no criminal procedure changes. So it just doesn't, it kind of seems to be backward forward to let Mr. Liu out and then to turn around for him to show up, but the state had to file a motion to revoke his bond, to have an Arthur hearing, to then put him back in. That seems to be counterintuitive to me and to my reading of the law. It's just that those two things don't seem to really make a lot of sense in the structure of which our legislature and our courts have made for our bond and release conditions. So that's why I think Arthur is appropriate, and the third stage reading of it is appropriate, because then you don't have these second layer review situations. You don't have Mr. Liu in a situation where he thinks he's out and he's back in, and then he's out and he may be back in at some point, and it's just that doesn't seem to be either fair to Mr. Liu or like to the whole process. It just seems to be a waste of judicial economy as well. It's not fair to him. It's not fair to the victims. It's not. It just seems to be unjust in that way. So, just right at this point, right now, I'm gonna just hold him and no bond. Judge LeBlanc, I'm quite sure, get you in there. If you file your motion today, I think he has, until like before the end of the week to get you in there. So we can get you in there as soon as possible.
May I share? As you know, I'm passionate about what I do, and I'm hyper-focused, obviously, on the rights of an accused. I appreciate your global perspective, trying to balance all those different rules and interests. As I articulated yesterday, and I would like to articulate again, I understand there have been amendments and constitutional amendments and Marcy's law, and there are alleged victims have rights. I've represented alleged victims in cases. But I don't feel those are paramount necessarily to the rights of an accused, which have always been in existence and are fundamental to our notions of liberty and freedom.
Right.
And in a situation where to me, I do not see a conflict in the sense that certainly there is a threshold issue of whether he's entitled to a bond or not, and that's the purpose of an Arthur hearing. But regardless, even if the court finds that Arthur is met and someone is not entitled to a bond, I've had in many instances courts nonetheless grant a bond, even in those non-entitled situations, using their discretion and not abusing discretion as such. And so that's kind of what I was asking to sort of skip over. Now, if it's a matter of alleged victim notification and the victim's rights, certainly, as I articulated yesterday, this warrant was issued I don't know, 5, 6 days ago. He was arrested 2 days ago. There's been ample opportunity for the state to notify the victim, which apparently they have, and she's expressed she does not want to participate. And apparently, as far as pretrial detention goes, it certainly makes clear that none of that matters unless and until the state files a pretrial detention motion, from my understanding.
Under 907.041, yes. But in the situation where those two kind of things kind of overlap, is that then there's our Constitution that says that, you know, if the state have an opportunity to show the proof to the court, there's proof evident presumption great by affidavit or some other form, and that's where the two differences lie. Because in under 907.041, the proof in that case, in the pretrial detention motion, is different than our Florida Constitution, and that's where I find the struggle. I wish that they would resolve this for us. I wish they would resolve this for the courts, because it'll make it a lot easier. There's a case that's been with our Florida Supreme Court since, I believe, the beginning of 2018, and they haven't said yes, no, this is the way you do it, this is the way you don't do it. Because under 907.041, the state we had to have a hearing within 5 days. They actually had to put on witnesses versus being by affidavit. There's the you know, and then you have to weigh a whole lot of other different factors that we don't necessarily have when those things are happening. I wish our legislature seriously would have a pretrial detention really statute, not demotion, not any of those things like that, about on cases there are life PBLs and capital offenses, and just have a section for that and a standard procedure we're supposed to follow. But really, at that point, the only thing we have is what the Florida Supreme Court told us in Arthur v. State, and some other kind of mixed DCA cases that have come along the way since then. Our DCA hasn't really weighed in that much in this area. There's one case out there where a court did find proof evident presumption great at our initial appearances, and then they told him that he was still entitled to Arthur hearing later on, partially because at that point the court, it was on as far as record purposes for the court, we weren't having this conversation. They just found proof evident presumption great. There was no question about whether it was Arthur hearing to conduct it and whether there was witnesses put on, anything, and you know. So it just seems to be a duplicative situation because the courts felt that they didn't have enough to say yes or no to Arthur hearing had a valid procedural basis. So.
I totally understand. That's a very good. I like I said, because of my hyper focus, I always, when there's a conflict in the law or uncertainty, I always would put the balance in favor of the presumption of innocence and the right to reasonable release to resolve that conflict. So that's all I was.
No, I understand, and I if there was something that I wish that would have happened while I've been sitting in here in this room for the last year, that is probably on the top of the list that I wish that would have been resolved by our legislature and or the Florida Supreme Court. But it would make my life dramatically easier up here.
I truly appreciate you giving me the time to be heard this morning and your patience in indulging my arguments. So.
No problem. Have a great day, Mr. Longwell. Good luck, Mr. Liu.
If I may, I'll step out and talk to you. Thank you.
All right. All right, so we had another reset yesterday in Santiago Rosado. Hey, good morning, sir. Can you tell me your name?
My name is Jan Santiago.
Sir, you're here in, I'm not sure, but case 2021 CT 7113 AO on the failure to appear. All right, so I think I reread this file yesterday. I want to get this correct. Mr. Santiago Rosado was arrested on this failure to appear warrant. The failure to appear warrant was to release him ROR with no other conditions, I'm guessing. I didn't read in the warrant.
Well, I read the ROR, I'm not sure.
They wasn't provided a new address, any of those things like that. 'Cause I'm asking you, was there any other, I didn't see anything, so I want to make sure that I missed anything. Just ROR. All right. So, let me pull this case up again. And you're represented by Richard Danshow? That you hired yesterday. As in, can you email Teresa and see if his attorney's gonna show up in this case? All right, Mr. Santiago, I just realized that you had an attorney. I kind of skipped by that just to get to the meat of what was going on. You hired somebody yesterday to represent you?
Yes, my parents did or something.
Your parents hired somebody to represent you? All right, let me reach out to them to see if they're gonna appear on this case. And we'll call you back up in a second. So then I'll make a record about what I think is going on, and then we'll move forward. Is that you all right? Ready for Christmas? You ready for Christmas?
I am.
Already? I'm still decorating. It's been a slow decorating season here.
You're ready? Did you say you're ready?
No, I'm not ready. It's been a slow decorating season. The tree is up now at least, and the trees are up. No decorations are on them. They're just kind of
Did you
up.
say
so.
trees, plural?
Yeah,
Well, that's
my
progress.
children live a different life than me. Completely different life that I don't understand.
They each get a tree.
They live a different life that I don't. Yeah, we're ready to go. I didn't grow up that way. Not at all. Yes, finally. We'll jump back to that in a second. All right. Good morning, sir. Can you tell me your name?
Good morning, Cody Cliche, sir.
Mr. Crochet, you're here in case 2021 CF 15618 AO on a charge of kidnapping, dating violence, and battery dating violence. I did review the charging affidavit. In this case, I did find probable cause for your arrest. State, what are you asking? Sorry, Ms. Crochet, I want to appoint the public defender to represent you, and state, what are you asking that I do as to count one of this charging affidavit?
Your Honor, count one is punishable by life. I ask defendant be held no bond.
Mr. Crochet, Ms. George, you have a response to the state's request?
I do, Your Honor. I'd ask that you use your discretion, given the facts of this particular case. I know you found PC. However, I would just ask that you consider the fact that it appeared he drug her back to the car. They got into an altercation, and then he let her out of the car. Could you?
Well,
Sorry.
It does not appear that he intended to, take her off and kidnap her, terrorize her, or anything like that. It appears an altercation occurred. He took her to the car to, talk to her about allegedly cheating, and then he gets upset, lets her out. So I just ask that you take that into consideration. It does not appear that the confinement was, for a long period of time or anything like that. So I just ask that you consider those factors.
yeah, I was on the line of false imprisonment and kidnapping, but then it's like if only the middle of the affidavit was there,
Yes.
but then like I have the beginning of the affidavit where the alleged allegations are is that he broke into the apartment, took her stuff, put it in the car. I don't know if it's true. It's an allegation. I have no idea.
No, yes, sir, I understand that.
I just have to go with what's on a sheet of paper.
Yeah,
Yes,
he
sir.
says affidavit.
Yeah, hold on, wait. So you're getting all like,
Yes, sir.
I'm just saying, I have to go with what's on a sheet of paper.
Yes, Your Honor.
So, and then at the end of the affidavit, you know, there's the situation at the gas station, and then that's when the dragging of that
Yes.
occurs. So that's where I was like, okay, then yeah, it's a kidnapping. He's like, you can
Yeah.
coerce her to get into the car, you know, then you know using some kind of force. Let me look at you. All right. All right, Mr. Cloche, in count one, I'm gonna set your bond in the amount of, actually, no, sorry, Mr. Cloche. Well, actually, in count one, I'm gonna hold you at no bond. Count two, gonna set your bond amount of $2,500. Condition of bond, no contact with the victim, no return to the scene of either of the locations, may not possess any weapons or firearms. Weapons or firearms you have need to return with law enforcement within 24 hours of your release. I'm going to order that you not possess or consume any drugs or alcohol without a valid prescription. Be subject to random drug and alcohol testing. Are appointed a public defender to represent you in this case. We'll get you in front of your division judge for Arthur hearing as soon as we can. All right. Good morning, sir. Can you tell me your name?
Charles Laverne Cox.
Mr. Cox, you're here in case 2021 CF 15606 AO on charge of contempt of order of no contact. I reviewed the charging affidavit in this case. Didn't find probable cause for this statute. So state, you want more time?
So there is.
921.44 has to do with sentencing no contact orders. It looks like that the case that there was referring that Judge Shoemaker ordered no contact was not a open case in 2021 MM 8149 AO.
Yes, Your Honor. I'm sure that there is an appropriate statute. I just don't know it
There is.
offhand right now, so.
There is just, so you asking for the 24 hours?
Yes, please, Your
All
Honor.
right,
Thank you.
all right. I want to talk to you, ma'am. Just give me a second. I just had to deal with some legal things first.
Yes, sir.
Good morning, ma'am. Can you tell me your name?
My name's Diane Cox. I'm his wife.
All right, and can you raise your right hand to be sworn in? Do you solemnly swear or affirm the testimony you're going to give in this matter is the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right, put your hand down. All right, so Mr. Cox is going to have to be seen tomorrow because the charge that which the law enforcement charged him with sounds like the appropriate statute, but the statute is not proper. It's for a different type of situation. So he's going to be seen tomorrow. But if you would like to if you'd like to be heard today, you can, or you can wait for tomorrow. It's up to you.
I don't care if I have to do both. I'd like to be heard today, but I'll come back tomorrow if I need to too, but,
It's your choice.
yeah, I would like to be heard today. I don't understand why he was arrested last night, okay?
Well, it looks like Judge Shoemaker ordered him to have no contact with you.
But we, neither of us knew that. I didn't know that. I bonded him out.
It looks like he knew that because there's an order that he signed saying that he's supposed to have no contact with you.
Okay, well, I didn't know whether he did or not. I did not know. Okay, he's been with me. And last night when he was fixing his bike, I didn't know if there was a no contact. He gets frustrated when he fixes the bike. I was gonna go to work, but I called the police and I let them know. I don't care if he stays here while he fixes the bike, but whenever I get home, so they're not arguing because he gets frustrated about fixing the bike, then he could leave. Well, they said that they started to arrest him, and I was like, whoa, what's going on? But that's when they told me about the no contact, and I said, but well, even if he was gonna get his property, then wasn't the police supposed to be called? So it was a
He was
big
supposed to call law
misunderstanding.
enforcement. So the order says this. He gives a one-time return with law enforcement to retrieve his personal items. You don't contact law enforcement.
That's what
It's
they
on
told
him.
me.
He has to contact law enforcement and then arrange with them a time with
I
you
didn't know that.
to
Or I wouldn't even
get
have
your stuff.
called them last night, though. I
Yeah,
would have never
I'm-
called them, because he wasn't there to argue with me or hurt me or anything like that.
Okay. All right. So, but right now, the no contact order from Judge Shoemaker still stands. You have to address those kind of situations with Judge Shoemaker because he's the division judge in that case. But so tomorrow you can come. It's up to you. We'll be seen tomorrow morning, and we will see if he's going to be released or not in this case.
So he's gonna be come back tomorrow for court for violation of a no contact?
If the state files, if they amend this to the right charge, then possibly. But right now, the charge that he's facing has to do with if you're sentenced in a case and you violate the no contact order in a case where you've been under sentence, that's a different situation than what we have here, where this is a pre-trial release no contact order.
Yeah.
All right. So he'll be seen tomorrow, and then you can come tomorrow morning. It's up to you whether you want to be here or not, but we'll address this case in the morning, okay? All right, you have a great day, ma'am.
Thank you.
Good morning, sir. Can you tell me your name? Oh, there you go. All right, tell me your name.
Nicholas Samuels.
Mr. Samuels, you're here in case 2021 CF 15406 AO on a charge of aggravated assault with a firearm, domestic violence, and shooting a missile into a dwelling or structure or vehicle. I believe I signed this warrant finding probable cause for your arrest. Gonna set your bond in count 1 in the amount of $25,000, count 2 in the amount of $5,000. Condition of the bond that you not return to the scene of the location that you maintain. This. I'll keep it. I'll say maintain a separate residence, one-time return with law enforcement to retrieve any personal items he has. No contact with any victims or witnesses, and even from the jail, and no return, no weapons, no firearms, weapons or firearms you have. Need to be returned over to law enforcement within 24 hours of your release. All right, have a good day, sir. Morning, sir. Can you tell me your name?
Javar Smith.
Mr. Smith, you're here in case 2021 CF 15614 AO on charge of aggravated battery on a pregnant person, domestic violence, or dating violence. They reviewed the charging affidavit in your case. It did find probable cause for your arrest. Going to set your bond in this case in the amount of $15,000. Condition of your bond that you have no contact with the victim in this case. You maintain a separate residence from this victim. If you have a shared residence, I'll give you a one-time return with law enforcement to retrieve any personal items you have at that location. You may not possess any weapons or firearms. The weapons or firearms you have need to be turned over to law enforcement within 24 hours of your release. I'm going to appoint the public defender to represent you in this matter. Do you have any questions about the stipulations of your no contact order? Yes, ma'am.
Your Honor, would you consider reducing the bond amount in this case?
Not in this situation. You seem to be out on bond already in the out-of-county case, as well as that you have prior domestic violence history in your past. So you have a great day, sir. All right. Have a good day, sir. Good morning, sir. Can you tell me your name?
Name's Adam Ayers.
Mr. Ayers, you're here in case 2021 MM 8681 AO on a violation of an injunction or no contact order. I did review the charging affidavit in your case. I did find probable cause for your arrest. Good morning, ma'am. Can you tell me your name and spell your last name?
My name is Chelsea Sandine. You spell my last name is Sandeen.
And can you raise your right hand and be sworn in? Do you solemnly swear or affirm the testimony you're going to give in this matter is the truth, the whole truth, nothing but the truth, so help you God?
Yes.
All right. Can you tell me how you know Mr. Ayers?
He's my fiance at the time, and my kid's father as well.
And you are the petitioner in your injunction 2021 DR 835?
Yes.
You're the petitioner, all right. And is there anything you wanted to tell me this morning?
Yes. So I'm gonna put my mask down because I can barely breathe. But what happened last night should have never happened. We actually went to court. We seen Judge Christy Collins back in July, and the injunction was actually dismissed by oral statement from Christy Collins, and everything was dismissed. I did look up on the Clerk of Court's website yesterday, and so did my attorney, and it does say that it is reclosed at the moment. There is also a statement or a document, rather, I'm sorry, on the Brevard County website, and that's what his attorney just expressed to me as well. That does say that the injunction is dismissed. So I'm not sure why the police came and arrested him, but it should have never happened. They came in my house. I did not give them permission to come in my house. My two babies were terrified, and it was just not a good situation. And like I said, it should have never happened. We have a neighbor downstairs
Hold on.
Okay, sorry about that.
All right, state in 2021 DR 835, looks like back in July, there was an order vacating the final judgment. On July 13th of this year, signed by Judge Collins.
I'm still looking for the injunction, Your Honor, but if that is what the court is seeing, it doesn't appear as though there is probable cause for the arrest.
Well, I'm not sure if it's probable cause for the rest of the injunctions done, please.
I have a question, if you don't mind me speaking.
Yes, ma'am.
Is there anything that I can do? Because like I said, last night.
Right now?
Excuse me?
Is there something you can do right now?
Yes, as far as what happened last night. Or is there
I'm
anybody
not
I
sure
can
what's
speak
going on
to?
with their system. Let's see something.
Okay.
1 second.
Thank you.
it seems to be a kind of an odd order. There's no certification of service on anybody, so that may be the issue. That the order was never sent to the, never, so it was a mail copy, I think, supposedly sent to you and at the sheriff's office, but I'm not sure that ever happened. So do you have a copy of the dismissal?
I do not, because I just recently found out about where to find it this morning.
Can you print line 58 for me?
But I have the link to it.
835. 21 DR 835.
Your Honor, I have it up so I can print it.
Oh, well, I mean, somebody slide it through the mail hole and so she have a copy of it.
Thank you.
All right. Mr. Ayers, looking at the injunction, we gotta take that back. I don't think there's probable cause for your arrest. State, you asking for any more time to
No, Your
investigate the situation?
No, I am not.
I had a question for you, Your Honor.
Well, I want to think you're gonna be happy with the next thing he's about to say. Mr. Ayers, you're gonna be releasing your own recognizance in this case. You have a great day. Yep. No, there's a mail slot right there. Yep. So it's held in your system too? There's an injunction?
What do you mean my system? And gist?
Yeah, I mean, I'm guessing so because it's on my face sheet.
I did
It's
look
active.
it up, and that's like what I put right here. It didn't say it was dismissed. It didn't say it was non-active or expired or anything. It still show as it's active.
It's interesting. Well, Mr. Ayers, you may want to get a copy of that same order.
Can you?
Yes, sir.
Did you close it?
Yeah, I can reopen it.
Thank you so much, because he's gonna need it for work, so am I?
Yeah, I'm not sure. I mean, we all depend on computers and systems. So in the system, technically, it shows even, that's why I asked the jail whether it showed in their system, whether it's still active. And it still shows active. So you may just want to carry that around for a little while. Maybe go talk to the sheriff's office. And I'm not sure. It says they were supposed to get served with this. Doesn't sound like that ever happened because it doesn't seem like she never got a copy of it, nor did the sheriff's office. So somebody may want to,
Yes, sir.
for your interest, you may want to go over there and talk to somebody at the sheriff's office.
I agree. I appreciate it, sir.
Yeah, because it says inactive on the thing. Like your braids, nice. Yeah, so I had to clean it up. The baby's been selling me out lately too. Daddy ain't got no hair. You're not so beautiful. You're not handsome, really, because you don't have no hair. That's what my baby's telling, because they only got all they long, thick hair than me. So I used to be like that back in the day. Good morning, sir. Can you tell me your name?
Joseph Robin.
Sir, you're here in case 2021 MM 8670 AO on charge of battery domestic violence. They reviewed the charging affidavit in your case. It did find probable cause for your arrest. Gonna set your bond in this case amount of $2,500. Condition on your bond, you're not allowed to have contact with this victim. You need to maintain a separate residence from the victim. Give you one-time return with law enforcement to retrieve any personal items you have at that location. You may not possess any weapons or firearms. Any weapons or firearms you have need to be turned over to law enforcement within 24 hours of your release. You may not also possess or consume any drugs or alcohol without a valid prescription. Be subject to random drug and alcohol testing in this case. We're going to appoint the public defender to represent you in this matter. Do you have any questions about the stipulations on your no contact order?
I can't see nothing.
Do you have any questions about the stipulations of your no contact order?
Listen, I wasn't touch my wife, but she just.
Yeah, don't talk about the facts of your case. The question is, do you understand my orders to you about the no contact?
Oh, yes.
All right, there we go. They ready for the interpreter?
Welcome to an Econo meeting. You are entering the meeting now. You are the only participant.
Okay. Is my TV plugged in down here? Is it plugged in? No, it's like, or somebody press the on button for me? No, remote's not. Hey, if you could slide it up just a little bit for me. Oh, yeah, use both hands. Yeah, use the hand. There we go. Boom, boom, right there. I don't know why it's not turning on though. Yeah, like it's dead. There we go. Hello, Madam Interpreter.
Hi, good morning.
Good morning. Can we call Mr. Dupree? Can you step back for 1 second? And can I get Mr. Dale Grand? And Madam Interpreter, you've been sworn in already this morning?
I have not.
Oh, you have not? Okay.
No, she did swear me in, I just realized.
If you can raise your right hand and be sworn in. Do you solemnly swear you'll translate from English to Haitian Creole and Haitian Creole to English to the best of your abilities to help you God?
I do. Isabel Durocher, Court Interpreter, Creole.
All right. All righty.
May I have the case number, Judge, please?
Yes, ma'am. It's 2021 MM 8672 AO.
867.
All right.
Thank you.
Oh, yes, yes. Yeah, that's right. All right. Good morning, sir. Can you tell me your name?
Bonjour, monsieur. Est-ce que vous êtes capable de dire qui j'en relais?
José Dallegrand.
Capable de dire qui j'en?
José Dallegrand.
Josier Dalgrand.
Sir, you're here in case 2021 MM 8672 AO on a charge of battery domestic violence.
Monsieur Oula, dans le cas 21 MM 8672 AO, dans un cas de violence domestique, attaque.
Yeah.
I did review the charging affidavit in your case. I did find probable cause for your arrest.
Moi, réviser attestation dans le cas où moi joindre que gain assez évidence pour y être arrêté.
I'm going to set your bond in this matter amount of $1,500.
Y a mette caution bon nous à $1,500.
Condition of your bond that you not have any contact with the victim in this case.
Ou pas capable gagner aucun contact avec victime dans cas ça.
You are to maintain a separate residence from this victim.
Ou besoin gagner un l'autre caille que victime dans cas ça.
I'll give you a one-time return with law enforcement to retrieve any personal items you have at that location.
Ou capable retourner en grande fois dans cas là côté OTE pour capable prendre tout à fait ou aller avec la police.
You may not possess any weapons or firearms. Any weapons or firearms you have need to be turned over to law enforcement within 24 hours of your release.
Ou pas capable gagner aucune arme ou bien arme à feu, toute bagaille que ou t'a gagné comme ça ou besoin de la police 24 heures après que ou fin relâché de prison.
I'm going to appoint the public defender to represent you in this case.
Ma bon défenseur public pour représenter ou dans cas ça.
Do you have any questions about the stipulations on your no contact order?
Est-ce que ou gen question sur ça, juge la sorte expliquer ou là pour affaire de nos contacts là?
Jon, pour affaire de nos contacts là, just pas comme pour ça, et juste pour affaire de $150 pour qui ça m'appelle. Charge.
Moi pas tendre ou bien. I can't, the interpreter cannot hear very well. Parlez plus près micro, parlez plus. Okay.
Charge m'appelle $150,000, besoin compte pour qui ça?
The charge that I'm going to have to pay $1,500, I need to know why.
You being charged with the crime of battery domestic violence.
Ou accusé de un crime que ou te fait violence domestique, ou te attaqué un moun.
You having contact or intended to injure a person against their will.
Ou te essayé faire un moun mal, ou bien ou te gagné contact avec un moun contre volonté li.
And that you had a domestic relationship with that person underneath the law.
D'après la loi, ou te gagné une relation domestique avec moun sa.
It is not a time for you to be proved guilty or not guilty of that charge.
Di c'est pas kounya que n'a prouvé ou soit coupable ou bien innocent de bagasa.
Today is a time for me to find probable cause and set release conditions, which I already done.
Ou capable bon non moun ça?
Jodi a, c'est seulement pour moi capable bon et conditions de relâche et joindre cause probable bagay que moi gen tan fait.
On the green sheet of paper that Ms. George is about to get you is going to be the phone number for your attorney.
Di sous papier que Madame Georges pral ba ou ap gen un numéro téléphone pour avocat ou.
You need to contact their office if you have any further questions about what's going on with this case.
Ou besoin contacter bureau yo aussi ou gen question à propos de cas ça.
Your Honor, I would ask, he was not interviewed for pretrial release. I would ask that he be screened for pretrial release in order to reduce the bond amount.
Avocat mandé pour yo capable et poser question pour relâche avant procès pour essayer réduire quantité bonne là, quantité l'argent bon. I have a question also.
Y a une question, moi besoin connaître qui est monde que moi te fait violence sur lui. Non.
I need to know who I was violent against.
All right, that's information that's going to be in charge on the order you're signing.
L'autre que vous signé information ça absolue.
All right. All right. Let's stop.
Campé.
Ms. Davis, tell me you qualify for pretrial release. I'm going to set your bond in this case amount of $750. It's going to come with pretrial release supervision. You'd have same conditions, no contact, no maintain separate residence.
I'm sorry, Judge. Y a descendre bon ou pour $750 kounya. Y a gagné même condition encore pour relâche avant procès que ça ou te gagné avant.
Non, c'est que
No weapons, no firearms.
ça n'a dit on pas connaître.
Pardon?
Tout ça n'a dit on pas connaître yo.
Everything that you say, I don't know what you're talking about.
Non, affaire de violence domestique et puis charge et puis
the violence, the domestic violence and the charge.
Yes, charge et puis rencontre personnelle entre la justice, moi pas contact avec la justice.
I don't have any contact. I don't have problem or contact with the justice. No.
I don't have. Moi pas contact avec la justice. Moi pas problème avec la justice, moi pas problème avec monde. Et ba moi non monde que moi fait violence.
I don't have any problem with anybody. Can you please give me the name of the person that I supposedly attacked?
Yeah.
All right. Well, it's on your paperwork. Have a great day, sir.
Tout bagay sous papier ou monsieur, passez bonne journée. Is that the only one, sir?
Yeah, I have one this afternoon. I didn't know if you were available.
I don't know anything about that.
Are you available at 1:30?
That's something that the office needs to decide.
Okay. Well, we'll see if we can contact them and I can get Judge Calderon on it, and we can see if you're available at 1:30 for me.
Okay.
All right.
All right.
Have a great day. Are you available if I need you at 1:30?
I am not the one to decide that.
Okay.
I don't know if I would be assigned or somebody else would be assigned. I cannot tell you whether I'm available. That's something the office needs to decide.
You're my only Haitian Creole interpreters.
Oh. Well,
You're my only Haitian Creole interpreter I think I've ever had.
There are others. There
Okay.
are others.
Maybe they connect us all the time.
Okay. Sorry about that. I can't.
All right, no
say
problem. You have a great day.
You too. Bye-bye.
Okay, well. Is there a Haitian Creole interpreter?
You are the only participant.
You have to use language signs. That's what I'm asking. You said, see, y'all confusing me, man. She just said she ain't the only one. And I'm like, you said. Okay, all right. A Haitian tribe? Creole tribe, is that him? All right. Hey, I'm just here. All righty. Good morning, sir. Can you tell me your name?
Good morning, Your Honor. Richard Dupree.
Mr. Dupree, you're here in case 2021 MM295AE on a charge of battery. They reviewed the charging affidavit in this case. I did find probable cause for your arrest. Good morning, sir. Can you tell me your name and spell your last name?
Jamal Thomas, Thomas.
Correction, can you do one more favor? Can you put this TV back down so now I can see Mr. Thomas? All right, you can raise your right hand and be sworn in.
Yes, sir.
You solemnly swear or affirm the testimony you're going to give in this matter is the truth, the whole truth, nothing but the truth, so help you God.
Yes, sir.
Okay.
All right. Can you tell me how you know Mr. Dupree?
That's my fiance.
All right. And do you want to have contact with him while this case is pending?
Yes, I told him I didn't want to press charges against
All
him.
right. Has there been any previous instance of domestic violence between you all in the past?
No, sir.
Did drugs or alcohol play a role in this incident?
No, sir.
All right. And State, you have any questions for the witness?
No, Your Honor.
Mr. Dupree, I'm going to appoint the public defender to represent you. Ms. George, you have any questions for the witness?
No questions, Your Honor. However, I would ask for a no hostile contact order given the victim's testimony here today and the lack of any domestic violence history.
Okay. Look at the case again. And State, what is your argument?
Your Honor, I have no objection.
All right, Mr. Dupree, I'm going to set your bond in this case, amount of $500. Is going to come with pretrial release supervision. You to have no hostile contact with your fiance. No hostile contact means this. You are in a relationship with Mr. Thomas, and in a relationship, things do come up where they're going to cause conflict. You don't have to agree with everything that goes on inside of your relationship. However, those disagreements, those arguments cannot become violent. They cannot become threatening. There can be no abusive language used between the both of you. Because no matter whether Mr. Thomas calls law enforcement or somebody that sees or hears you all arguing calls law enforcement, you're going to be arrested for violating my orders. You're going to spend a lot of time here at me, the Orange County Jail, on no bond status. You understand that?
Yes, Your Honor.
You also may not possess any weapons or firearms. The weapons or firearms you have need to be turned over to law enforcement within 24 hours of your release. You also may not possess or consume any drugs or alcohol without a valid prescription. Be subject to random drug and alcohol testing while you're out on release in this case. All right, are you appointed to public defender to represent you? You have a great day, sir. You have a great day, sir.
Yes, sir.
Good morning, ma'am. Can you tell me your name?
Julissa Guevara.
Ma'am, we're here in case 2021 MM 8656 AO on charge of battery domestic violence. They reviewed the charging affidavit in your case, did find probable cause for your arrest. Going to set your bond in this case amount of $100. It's going to come with pretrial release supervision. You have no contact with the victim in this case. You're to maintain a separate residence from this victim. I'll give you a one-time return with law enforcement if you need to retrieve any personal items you have at that shared location. You may not possess any weapons or firearms. The weapons or firearms you have need to be turned over to law enforcement within 24 hours of your release. And I'm going to appoint the public defender to represent you in this matter. You have a great day, ma'am. morning, sir. Can you tell me your name? Sir, you're here in case 2021 MM 8675 AO on a charge of battery domestic violence. Did review the charging affidavit. In this case, I did find probable cause for your arrest.
Your Honor, I had a PC challenge.
Go ahead.
Your Honor, in this particular case, I would argue no PC based on the arrest affidavit. The alleged victim did not witness, not the victim, the mother did not witness the altercation, and both my client and the alleged victim stated that nothing occurred. So I would argue no PC. I would argue there was no touching against anyone's will. The victim stated they fell, but there's no indication that, based on the arrest affidavit, that there was a touching against the victim's will.
State. It's borderline. I'll give you that.
Your Honor, I believe there's enough information here to infer that two brothers were fighting with each other. When you see two men on the floor after you hear a commotion and one of them is bruised, both of them being on the floor and one of them being bruised, I believe indicates that there's a fight.
Your Honor, I would just argue that the statute states you must prove there's an intentional touching or striking against the person's will. There were only two people involved in the altercation. There were no other witnesses. Both brothers denied any type of physical contact with each other. Thereby, there can't be an intentional touching against someone's will when both are stating that no physical violence occurred.
So I guess let's extreme this a little bit. If you're in a room next, there's a butts up to another room, and you hear, fists and hitting meat and hands, and you go next door, one of somebody's dead and the other person isn't. There's only two people in the room.
Right, Your Honor. However, I would just argue in this situation, again.
That's extreming the situation, obviously, but from the witnesses, they said they hear a fight going on next door or in the other room, and then I don't know if it was over FIFA or Halo or something. It's a new Halo coming out, right? I think.
Yep, we don't know, Your Honor.
I don't know what the argument was about, but somebody's on the floor and then somebody,
Right. Both parties were found on the floor. However, she stated she heard the commotion, but again, it could have been anything. We don't know. But the only two people that were there were both brothers, and both brothers denied the allegations. And the victim stated my client did not hit him. And because of that, I would argue there is no PC because there is no intentional touching or striking against his will.
Let me think about it. Let's talk about this failure to appear case in 2021 CT 5466 AO Say, was there an offer to resolve that case?
Not at this time, Your Honor.
No valid driver's license?
Oh, is that what it is?
Yeah. Did you get your license back?
Huh?
You have your license?
Nah, I never went to the court date.
Well, I know that. We know you weren't there because that's why you got a warrant for your arrest. But the question that I have is, did you go to the DMV and get your license back?
Yeah,
Or
actively, I was trying to get them.
you trying to do that still?
I'm practicing doing the test. I don't want to just go to the DMV and just fail it.
You gotta get your 3-point turn on. You gotta look behind you when you're backing up. You gotta park, negotiate some turns and stops. I mean, our test is relatively not as complicated as some other people. You don't have to parallel park. You don't have to do any of that thing in the state of Florida. All right. I'll do this. Although I do think there's enough of probable cause. I mean, I'll say there's PC, but as the 2021 MM 8675AO, I'll still release you in your own recognizance as to that charge.
Your Honor,
Conditions are,
only because it's a dangerous crime is the only reason why I,
yeah, so that's the thing. So the statute says the person not entitled to non-monetary release doesn't relieve the judge of 2 things. It says releasing somebody on own recognizance, electronic monitoring. A lot of these cases, I would do electronic monitoring if we had it, but we don't. So I have 2. It narrows my options down to 2: RR or money. So
I don't, even if it's $50, Your Honor,
Your Honor, I would ask based on these facts. Normally we don't,
Let me show- let
but
me
based
read.
on these facts, I would ask for the ROR.
I mean, let me show. I want to misquote the law, so let me do that. Let me look at it again. Make sure they haven't changed it. 907.041 sub 2. I mean, sorry, sub 3. B says that no person charged with dangerous crime should be granted non-monetary pretrial release at first appearance hearing. However, the court shall retain discretion to release an accused on electronic monitoring or on recognizance bond if the court finds on the facts, the records, factors, or the circumstances warrant such a release. So technically, in most cases, I don't, because I think the facts don't rise to me doing that. The only reason and truthfully, it was close cause, a probable cause. We just had a homicide here last week where essentially that's where the facts, I mean, other than the person admitting to that he killed his father, those were the facts of the case. 2 were in an apartment by themselves. There was a scuffle. He beat him to death and called 911 saying he tried to revive him, resuscitate him, but minus the fact that he admitted to doing it. Would there still be probable cause to arrest him? Is the question. So, I mean, as I was saying, that's why I streamed the facts out, because that's basically what the facts were.
Yes.
Other than him admitting to, to doing it. So that's the reason why, I still think even if he didn't admit to do it, it'd still be probable cause to arrest him for the possible homicide.
Right.
But in this particular situation, I don't know what these 2 young men are arguing about that caused them to get into this fisticuff. But you can't fight with your brother like this no more, because you get arrested nowadays because you're an adult.
I see that.
Yeah, I'm just telling you. So I mean, like, you know, when you guys probably used to get down, like, you know, with your brother back in the day, and you know, y'all used to get after it. You can't do that. So, only question that I have is that you think that I should still order him to have no contact with him? That's the real question. I wasn't gonna say anything, but that's the real.
I believe because the victim isn't here, we have to.
I have to order it. That's what I'm saying. That's the only next thing is I have to order that you have no contact with your brother. At least you're on reconnaissance as to this. You still got to post your bond and your failure to appear case, $500. No contact with the victim. Maintain separate residence from the victim. One-time return with law enforcement to retrieve any personal items you have at the location. The weapons and firearms, any weapons and firearms you have need to be turned over to law enforcement within 24 hours of your release. In order to ask you also to not operate a motor vehicle without a valid driver's license. No, this is one case. No, it's in that case. Yeah. Yeah. Judge didn't put it in.
So
On the warrant itself, the FTA warrant, the judge didn't give me the option for that, so. I read the warrant, it just said $500 bond, no other conditions.
Yeah.
They gave me the option, you don't think he still would qualify, he's got an open case. Hey, you gotta pay something, He didn't pay bond on the case before, it's basically, it's a net $500 situation for both cases. Talking to Ms. Davis, like, $500 basically for both cases, is essentially what I did. I'm not changing nothing.
That's why I was confused.
Good morning, ma'am. Can you tell me your name?
Jenny Regal.
Ma'am, you're here in case 2021 MM816AW on charge of battery domestic violence. Did review the charging affidavit in this case. Did find probable cause for your arrest. Okay, wonderful. Going to set your bond in this case amount $250. It's going to come with pretrial release supervision. You have no contact with the victim in this case. You are to maintain a separate residence from this victim. I'll give you a one-time return with law enforcement to retrieve any personal items you have at that location. You may not possess any weapons or firearms. Any weapons or firearms you have need to be turned over to law enforcement within 24 hours of your release. And I want to appoint the public defender to represent you. You have a great day, ma'am.
Sorry.
All right. Good morning, sir. Can you tell me your name?
Carla E. Sunkin Jr.
Sir, you're here in case 2021 MM8674AO on charge of battery dating violence. I did review the charging affidavit in your case. I did find probable cause for your arrest. Going to set your bond in this case in the amount of $500. It's going to come with pretrial release supervision. You to have no contact with the victim in this case. You are to maintain a separate residence from this victim. I'll give you a one-time return with law enforcement to retrieve any personal items you have at that location. You may not possess any weapons or firearms. Any weapons or firearms you have need to be turned over to law enforcement within 24 hours of your release. And I want to appoint the public defender to represent you. You have a great day, sir.
Can I ask one question?
I want to appoint a public defender to represent you. How to talk to Ms. George, because everything you asked me is on the record.
That's all I need to know.
All right, have a good day, sir. Good morning, sir. Can you tell me your name?
Nathan Oliver Dixon.
Dixon, you're here in case 2017 CF 166, case out of Taylor County on a violation of probation. Bond is no bond. Bond's going to remain at no bond in that case. You seem to be a violent felony offender of special concern, not entitled to release or bail on bond on that case until you resolve it in Taylor County. I'm going to appoint the public defender to represent you in this case. You have a great day, sir. Yep, you got some other charges you're going to be seeing on tomorrow with court, for my information. Yep, you got the charges you picked up. You're arrested on some other charges. You're going to be seen on those tomorrow.
Hey, I picked up other charges.
Some add-on charges.
Some add-on charges that I see that you're going to be heard on tomorrow. Good morning, sir. Can you tell me your name? Mr. Hendricks, you're here in case 2021 CF 1915 AO on a charge from Seminole County on a violation of probation. Bond in that case is no bond. Your bond is going to remain at no bond. I'm going to appoint the public defender to represent you to get you over to Seminole County. You have a great day, sir. All right. Good morning, sir. Can you tell me your name?
Sean Jackson.
What happened to Winter? Jackson?
I'm sorry, Justin Winter is in the hospital, yeah.
And then, all right, so going to appoint the public defender to represent Mr. Winter.
I'll waive the appearance, Your Honor.
All right, he has a 2019 MM315562 case from Volusia County. Bonds $500 on failure to appear. And Calderon.
Calderon's behavior, Your Honor.
That's 2021 CF 2979 AO. Going to appoint a public defender to represent Mr. Calderon.
I'll waive the appearance, Your Honor.
He's here on a violation of probation. Judge, like you said, his bond amount $2,500 is going to remain as set. All right, good morning, Mr. Jackson. You're here in case 2004 CF 10004 on a violation of probation. Judge signed your warrant, set your bond at no bond. Bond's going to remain at no bond. Seem to be a violent felony offender, special concern. Not going to be entitled to release or bail on bond on that case. Going to appoint the public defender to represent you in this matter. You have a great day, sir. Good morning, sir. Can you tell me your name?
My first name is Raid, middle name Ode, last name is Mualla.
Sir, you're here in case 2020 CF 6435 AO on a charge of violation of probation. Judge signing your warrant in this case set your bond at no bond. Your bond's going to remain at no bond. Condition your bond is to have no contact with the victim from the jail. Going to appoint the public defender to represent you in this matter. You have a great day, sir. Good morning, sir. You can tell me your name?
Kevin Eugene Sullivan.
Sir, you're here in case 2020 CF 11733 AO on a violation of probation. Judge signed your warrant in this case set your bond at no bond. Your bond's going to remain at no bond. Going to appoint the public defender to represent you in this case. You have a great day, sir. Good morning, sir. Can you tell me your name?
Jeffrey Nathan Torrance.
Sir, you're here for a few matters. The first one being 2021 CF 15613 AO on charge of possession of methamphetamine and possession of drug paraphernalia. Reviewed the charging affidavit in this case. Did find probable cause for your arrest. Say your bond, count 1, 1,000, count 2, 100. Condition of your bond, no drugs, alcohol without a valid prescription. You're on probation in case 2020 MM 6448 AO and in 2020 MM 6316 AO. Court is finding on-view violations of probation. The on-view probations were filed in those cases. Did find probable cause. Going to set your bond at no bond in those cases. We're going to appoint a public defender to represent you in those matters. So you want to wait for the affidavits to be filed, or you want to enter denial right now? I'm quite sure I want to sign some warrants in a little bit. You want to see them tomorrow when the warrant's signed.
What happened, sir?
I'm quite sure I'm going to get some warrants when I get back to my chambers about this. But you wait for so my problem is you want to enter the denial now or wait for the warrant to be wait for the warrants. Huh?
Yeah, just wait for the warrant.
Say again?
Just wait for
the warrants. All right. All right, so I'm going to appoint a public defender to represent you in all your cases. You have a great day, sir. All right, good morning, sir. Can you tell me your name?
Morning.
All right, sir, you're here in quite a few matters. 2020. Oh, this is hard to look at. All right. Sorry, say your name one more time.
Timothy Aponte Rosario.
All right, Mr. Aponte Rosario, you're here in a few matters. First one, 2020 CT 207 AW, 2021 CT 413 AW, 2021 CT 415 AW, as well as 2020 CT 1206 AO, and 2020 MM 205 AE, all for violations of probation. Just signing warrants in this case, set your bonds at no bonds in all your cases. Going to appoint the public defender to represent you in all your cases.
correction. I'm so sorry, Your Honor. And the warrant 20 MM 205 AE.
Yes, ma'am.
Is a $5,000 bond.
It's $5,000. Just in that one?
Just in that one.
All right. Okay. I guess in 2020 MM 205 AE, a bond in that case is $5,000. Our remaining bonds are 0. going to appoint a public defender to represent you in this case. Ms. George, you want to enter denial on all the cases?
Yes, I'll enter denial.
Yep.
Those are all Division 61. Division 61 VOP status is January 25th at 10:30 a.m. in 6B. I'm sorry, I
January
missed the quarter.
25th, 10:30, 6B.
And you said January or December? January 25th. 10:30. VOP status is going to be December the 21st at 9:30 a.m. in 9C.
This is my first violation.
You got another. Okay.
Same as
1206AO, that is Division 62, and that VOP status is January 10th at 9 a.m. in 9B.
All right, so let me get this Mr. Santiago Rosado back real quick, and then we'll be, I think, closed out for the morning. All right. Good morning, sir. Can you tell me your name?
Jan Santiago.
All right, Mr. Santiago Rosado, you're here in case 2021 CT 7113AO. We tried to reach out to your attorney. We haven't got a response from them. Seems you're supposed to be released ROR as to that charge. There's a case out of the 4th DCA saying I can't take any action on your other cases since we don't have any jurisdiction over you right now. So I'm not going to do that. So you're released on your own recognizance and not taking action on your other cases.
Go home.
Yeah.
Go home, right? Thank you, sir.
Mm-hmm.
Your Honor, do we have a VOP on Carrie Tyrell?
That's a, parole. That's parole.
Okay.
They're
Oh,
at
parole.
CIA.
Okay,
Yeah.
thank you.
All right. You have anything else for the morning?
Nothing from the state.
Nothing from the
Ms. Davis?
Nothing, Your Honor.
To say? And Denise? All right. All right, I have a training in the downtown. So.
Sworn.
Good morning. Well, good afternoon, Ms. Laura. This is Judge Bancom from the BRC. I have a few defendants I need your help with. The first one I have is Mr. Lopez Morales, and we're going to hopefully get him to the podium in a second here. All right. Hey.
Connection is established.
All right. Good morning, good afternoon, sir. Can you tell me your name?
Joel Damian Lopez Morales.
Joel Damian Lopez Morales.
Mr. Lopez Morales, you're here in case 2021 MM 7578AO. We're being charged by information with the crime of petty theft for the prior theft conviction.
Sorry, Your Honor, it didn't come through very clearly.
He's being charged with the crime of with petty theft for the prior theft conviction. That is a first-degree misdemeanor, punishable up to 1 year in the county jail and a $1,000 fine. Ms. George, what plea do you want to enter on behalf of Mr. Morales, Mr. Lopez Morales?
Not guilty, Your Honor.
Mr. Lopez Morales, I'll accept your plea of not guilty as to these charges. I want to set you for pretrial conference in Division 85 on the following day.
Division 85, pretrial conference, January 24th at 9 a.m. in 4A.
I'm sorry, Your Honor, if you could repeat those dates, I can barely hear the clerk.
It's January 24th at 9 a.m. in 4A.
Thank you.
You have a good day, sir.
Buen día.
Good day.
Yes, please. Yeah, go ahead. Good morning, good afternoon, sir. Can you tell me your name?
Wilberto Ayala Vélez. Wilberto Ayala Vélez.
Wilberto Yala Vélez.
Sir, you're here in case 2021 MM 8668 AO on charge of trespass on property after warning. I reviewed the charging affidavit in this case. I did find probable cause for your arrest. I want to ask the state if you have an offer to resolve this case.
Recorded adjudication, credit time served. No return to Wood Spring Suites, located at 1934 McCoy Road.
Mr. Ayala Velez, do you want to accept the offer from the state of Florida of a withhold adjudication of guilt, credit for the time you spent in the Orange County Jail and court costs in this case?
Pues sí.
Well, yes.
Yeah.
Can you raise your right hand and be sworn in? Do you solemnly swear or affirm the testimony you're going to give in this matter is the truth, the whole truth, and nothing but the truth, so help you God?
Sí, lo juro.
Yes, I do.
You put your hand down. Sir, the charge you're facing is a first-degree misdemeanor. It's punishable up to 1 year in the county jail and $1,000 fine. You understand?
Sí, sí.
Yes.
Do you want to enter a plea of guilty or no contest to this charge?
No contest. No contest.
You have to answer me out loud.
Okay, como...
No contest.
No me opongo.
No contest.
Do you understand by entering a no contest plea, you're going to waive all the rights on the plea form written in Spanish in front of you?
Okay, sí.
Okay.
Yes or no?
Yes.
Are you under the influence of any drugs, alcohol, or medication?
No.
No.
Have you now or in the past been diagnosed with a mental health illness?
No.
Has anybody forced, threatened, or forced you to enter this plea?
No.
No.
Do you understand by entering this plea, if you're not a United States citizen, could subject you to deportation from this country?
Sí, entiendo.
Yes. I understand.
I did have opportunity to review your charging affidavits. I did find a factual basis contained therein for the purposes of entering your plea. I accept your plea of no contest, find your plea is freely and voluntarily entered. I will withhold adjudication of guilt. I'll give you credit for the 2 days you spent in the Orange County Jail with 2 days credit time served. Court costs and costs of prosecution in this case are $273. I'll give you 1 year from today's date to pay that money directly to the clerk in full. You have 30 days from today's date to appeal your judgment and sentence in writing. You have a great day, sir. Mr. Blanker, I'll give it to you after I get through these interpreter cases.
I'm not in any rush.
Good afternoon, sir. Can you tell me your name?
Wilmar Marvin Gonzalez Gonzalez.
Wilmar Marvin Gonzalez Gonzalez.
Mr. Gonzalez, you're here in case 2014 CT 6597 AO on a failure to appear warrant on the charge of no valid driver's license. Bond in your case is $2,000. Bond asks the state of Florida if they have an offer to resolve this case.
Withhold of adjudication and credit time served.
Your Honor, he already has it. It looks like an immigration detainer, so I would recommend that he wait to resolve it. I don't know how that's gonna affect anything.
All right, sir, it looks like you're gonna be maybe detained by the Immigration and Customs Enforcement Agency of the United States government. I'm gonna state your bond in this case amount of $2,000. I'm not gonna take any action on your auto bond case in 2021 CF 14734AO. You have a great day, sir.
Gracias.
Thank you.
That was my last Spanish case, correct? Thank you, Madam Interpreter.
You're welcome, Your Honor. The interpreter will disconnect.
File is this? This is this morning's file. I'm confusing me. Like you put this file close to me, like it was the one I'm using. All right, let me grab Mr. Blanker's client, Finnegan. All right. Good afternoon, sir. Can you tell me your name?
Robert Finnegan.
Mr. Finnegan, you're here in case 2021 CF 15330AO on a warrant signed by a judge finding probable cause for charges of lewd and lascivious battery in 2 counts and 1, 2, 3 counts of lewd and lascivious molestation of a child between the ages of 12 and 15 years old, and 1 count of lewd and lascivious conduct by a person over the age of 17 years old, and 2 counts of contributing to delinquency of a minor. And Mr. Blankner, you put your name on the record?
Yes, F. Wesley or Francis W. Blankner on behalf of Mr. Finnegan, Your Honor. We're asking the court to consider setting bond in this matter. I believe he's entitled to bond on these charges. I actually appeared with him in Seminole County, advising him that he could not post bond in that county till we came before court in Orlando. And he's been up there, I'm going to say 5 days, approximately. I think that's the number of days. I think I was there last Friday, if I'm not incorrect. Today's Thursday, am I correct, sir? I think so. Yeah. He would either be living with his mother or his father. His mother's actually helping pay his legal fees. She lives in Brevard County, Florida. His father lives in Winter Springs. He's been staying with his father, and that's where he was when he got arrested. That's why he was arrested in Seminole County. And he's available to have both residences, and both parents have agreed that they would keep him till the case was resolved.
And state, correct, these are, I think one is an F1, a couple of these are F1s and the rest of them are F2s.
That's correct, Your Honor. Nothing is a PBO.
And did we reach out to the victims in this case?
Not that I'm aware of, Your Honor.
I believe she lives in Orange County, Florida. That's why the charges are here at the present time.
Yeah, I'm just trying to ascertain. I think we've been having a slight issue with these warrant cases and victim contacts. All right, sir. On the counts that are set at no bond, we're going to set your bond in the amount of $25,000 on each count. Condition of the bond still remains the same: no contact with any victims or witnesses, even from the jail or any jail you're at. No return to the scene of location. No weapons, no firearms. The weapons and firearms you have need to be turned over to law enforcement within 24 hours of your release. You also have no unsupervised contact with any child under the age of 18 years old. I'm You have Mr. Blankton representing you in this case? So you should lean on his representations.
Myself and Mr. Ali both, we're both involved in his case.
Say again?
Mr. Ali, my partner, is also
Okay.
involved in the case.
Well, you have
Can I
the
ask the court one
firm
thing?
of Ali and Blankner representing you in this case, and you can lean on their representations for
Thank you.
this case.
Could I ask the court to consider lowering the bond on the last two counts because they're misdemeanors? I understand the
500.
felony charges.
I think the last two counts were, I think,
I think
500.
the last two are contributing to the delinquency of a minor and contributing to the delinquency of the minor. If there's no, I didn't know what the court was doing with those.
No, I was saying the ones that he didn't have bond, I gave him bonds, and the other ones will remain the same.
All right.
So still 500 on the contributing delinquency charges, and then
Okay.
25 on the rest of them.
All right. Thank you, Your Honor.
All right,
Appreciate
no
your
problem.
time.
You have a great day.
Thank you. Have a good day.
Yes, ma'am. Yes. Why didn't you give him out of county custody? If you want to give him out of custody, is he still serving time? Why is he here? Why are you giving him out of county, out of court, out of custody arraignment? In the mail. Show up there. Oh. Okay. I was like, okay. Super confused. All right. All right. Good afternoon, sir. Can you tell me your name?
Michael. Taylor.
Mr. Taylor? All right, can we do the arraignments after Mr. Taylor? The last two arraignments after we're done with Mr. Taylor here. Mr. Taylor, you're here in case 2021 MM 8673 AO on a charge of trespass on property after warning. I reviewed the charging affidavit in your case. I did find probable cause for your arrest. Well, as the state, did they have an offer to resolve Mr. Taylor's case?
Adjudication of guilt, credit time served, no return to the 7-Eleven located at 327 South Orange Blossom Trail.
Mr. Taylor, do you want to accept the offer from the state of Florida of an adjudication of guilt, credit time served in this case?
Yes.
Can you raise your right hand and be sworn in? Best you can. There you go.
Like this?
There it is. You solemnly swear or affirm the testimony you're going to give in this matter is the truth, the whole truth, nothing but the truth, so help you God.
Yes.
You put your hand down, sir. So the charge you're facing in that case is a first-degree misdemeanor, punishable up to 1 year in the county jail and $1,000 fine. Do you understand?
Huh?
The charge you're facing, the maximum penalties for it are 1 year in the county jail and $1,000 fine. Do you understand?
Yeah.
Do you want to enter a plea of guilty or no contest to resolve this case?
Guilty.
Do you understand by entering a plea of guilty that you don't waive all the rights outlined on the plea form that's in front of you?
Huh?
You certainly waiving your rights to have a trial in this case, to have an attorney appointed to represent you, challenge the state's evidence, call witnesses on your behalf. Do you understand you're waiving all those rights?
Yes.
Are you under the influence of any drugs, alcohol, and medication?
Not really, no.
Have you now or in the past been diagnosed with a mental health illness?
Yes.
What was that mental health illness?
Schizophrenia.
Are you taking any medications for your schizophrenia at this moment?
Yeah.
Do those medications help you understand the world that's going on around you?
My mother died. I was just sitting there trying to get some money to buy something to eat.
Yeah, I got you. But do you understand, do the medications help you?
Not really.
All right. Are you suffering from any of the symptoms of your schizophrenia right now?
Not really.
All right. Are you hearing any delusions, any voices? Are you seeing?
Yeah, see, I hear voices.
You hear voices? You are hearing voices right now?
No, not really.
All right.
They gave me a shot in the hospital. I just left. Coming home from where I was at. I usually stand out there and panhandle.
Okay.
So I can get something to eat.
I got you.
She died. I have no family.
Gotcha. Are you, sorry, you understand if you're not a United
Those
States
people
citizen?
weren't able to
One second.
work. I wouldn't be planning on, you know what I'm saying?
I got you. Let me ask you one more question. You understand if you're by entering this plea, if you're not a United States citizen, you could be deported from this country.
Yeah, but I am a United States citizen.
All right, wonderful. I did have an opportunity to review a charging affidavit in this case. I did find a factual basis contained therein. Going to accept your plea of guilty in this case. Find your plea is freely and voluntarily entered. Going to adjudicate you guilty of the charge. Give you credit for the 2 days you spent in Orange County Jail with 2 days credit time served. Court costs and cost of prosecution in this case are $273. Give you 1 year from today's date to pay that money directly to the clerk in full. You have 30 days from today's date to appeal your judgment and sentence in writing. You have a great day, sir.
Okay.
All right. Okay. All right. And as well, I guess it's official, Judge Gibson and I will no longer be in Division 51 and 52 starting January 4th, I believe, at the beginning of the year next year, January 3rd. And we'll start the county judge rotation at that point.
So you won't be out here?
I will be here, but not in this division. I'll be in a Division 75, which will be a new civil division, until my chambers are finished on the 14th floor of the courthouse.
Moving on up.
Hmm? Probably put in some of my drops for my contacts. Well, I mean, I have my mind set. We're gonna be here till March, and then now we're changing it up. All right, I had an arraignment for a Levon Richardson, 2021 MM 8595 AO. I want to appoint a public defender to represent him in this case.
I'll waive the appearance and enter plea of not guilty, Your Honor.
Then I have another one. That's Santiago Savita, 2021 MM 7673 AO.
Yeah, time served.
I guess he wasn't time served, I guess, on this case. He was time served on another case. It's a summons case, so I'm gonna appoint the public defender to represent him in this case.
He's not here?
Yeah, but so he's not in custody at all here.
I guess, you want me to set the outside arraignment date, or do you want me? He's not here, like, he's gone.
Released on
All right.
December the 2nd.
We're gonna set an outside arraignment date for him in Division 82. Or I think they're reinstituting the new arraignment calendars that they used to back in the day. All right. So, Mr. Johnson. All right. Good afternoon, sir. Can you tell me your name? Mr. Johnson, you're here in case 2021 MM 8665 AO on charge of battery and resisting officer without violence. They reviewed the charging affidavit in your case, did find probable cause for your arrest. Going to set your bond in count 1 in amount of $2,500 and count 2 in amount of $100. Condition of the bond, no contact with the victim, no return to the scene to location. You may not possess any weapons or firearms. Any weapons or firearms you have need to be turned over to law enforcement within 24 hours of your release. I'm going to appoint the public defender to represent you in this case. It seems that you're out on bond in 2021 CF 14214 AO for another battery with another prior battery conviction. Court finding probable cause that you committed a new law offense while you're out on bond. It's going to revoke that bond, set a new bond at $0 in that matter. I believe you already had the public defender appointed in that case. You have a great day, sir. Good afternoon, sir. Can you tell me your name?
Nicholas O'Neill.
Mr. O'Neill, you're here in case 2021 CF 15573 AO on charge of battery with a prior battery conviction. They reviewed the charging affidavit in your case. They find probable cause for your arrest. We're going to set your bond in this case in amount of $2,000. It's going to come with I'm going to order that you have no contact with the victim in this case. Not return to the scene to location. You may not possess any weapons or firearms. The weapons or firearms you have need to be turned over to law enforcement within 24 hours of your release. And I want to appoint the public defender to represent you. You have a great day, sir.
Your Honor, Mr. Charles refused.
All right, it's 2021 MM 283 AW. Mr. Charles. You already have the public defender. I want to appoint the public defender to represent him.
I'll waive the appearance, Your Honor.
All right, he's here for a, what's he not on my screen? He's here for a failure to appear warrant. Bond is $250. It's going to remain a set. All right, Mr. Clark.
Mr. Clark is medical.
You be anticipating to be medical for a long period of time, or? All right, we'll reset Mr. Clark for tomorrow. Yeah. And do we have the Creole interpreter? Do you call them and see if they? No, I'm saying like, can you call the regular interpreter people and see if this trial actually went through? That's what I mean, like, cause things is after lunch now, and judges should have figured out whether they actually, your trials are actually going or not right now. All right, and, all right, Alan is the next person.
Alan refused, Your Honor.
Dion Allen, 2021 MM 815 AW. I'm going to appoint a public defender to represent him. All right, he's here for a charge of
He bonded, Your Honor.
Allen bonded. All right,
Dion Allen.
Dion Allen bonded. All right,
He's released.
Michael Flowers is my next person. The interpreter is not available. No, I was just with a bunch of circuit judges, and we were talking about it a while, so. All right. Warren, sir, Gathering, sir, can you tell me your name?
Yes, sir. Michael Flowers.
Mr. Flowers, you're here in case 2021 MM 8677 AO on charge of battery. The court did review the charging affidavit in this case, did find probable cause for your arrest. Gonna set your bond in this case amount of $1,000, condition the bond that you have no contact with the victim, not return to the scene, the location, cannot possess any weapons or firearms. Weapons or firearms you have need to be turned over to law enforcement within 24 hours of your release. I want to appoint the public defender to represent you in this case. So I was checking. Actually, Pleato, that's something I was looking for. There was something weird about this. I looked it up earlier.
Yeah, I have no open cases at all, Your Honor.
Closed in our system, and it's closed in.
But where's the, like, I guess my thing is, where's the paperwork from the plea?
Your Honor, on our system, I was able to get the disposition page, but I couldn't find it in clerks, but in our system, it does show that on March 4th, he pled to 33 days. It was a credit time served off.
All right, I see a notice, let me see a notice of hearing for March 4th.
Yeah, I pled from another.
Oh, wait. Madam Clerks, can we follow up on this case and see what happened? Mr. Perkins, Judge Perkins is in what county? You said you pled from another county. Judge Perkins is in what county? Where are you in?
I was in St. Augustine County. He was in Daytona, and my lawyer from here was here. We did like a global thing over the computer.
No. Yeah, you spent in St. Augustine County. And for, like, it looks like something that happened that may have been, so the paperwork may be Brevard or St. Augustine, but we need to follow up and make sure that we have that paperwork for our records. Because he's gonna continue to get arrested on this, and maybe, because based on this is open. State, you say you have a disposition sheet from, is it from Brevard or St. Augustine?
You know, I just saw that it was a disposition, but let me look at it again.
I pled to 33 days time, sir.
Yeah, I know, but I'm trying to close out this case in our system, because anytime you get arrested again, or some other judge may look at this and like now set you for new court dates, and the clerks may set you for new court dates because the case is open because it's not closed in our system. This looks like an open, active case.
Oh, yeah, great, thank you. Do I give it to you or the clerk?
You give it to the clerks, that's fine. Whatever you have, and we can try to, obviously we need some fingerprints and stuff like that later on, but something we can start with researching. Yeah, no, I said this is a research point. Well, this is the sheet from the state attorney's office. Right. No, you gotta get stuff over to the clerk's office in
No,
the county which he pled in. Yeah, so we need to figure out what happened
okay.
at those different points, because otherwise, Mr. Flowers is gonna be in the short end of the stick at some point.
So am I gonna be able to bond on this with no issue and be able to get out of jail?
I'm not gonna take any action on it because the parties in front of me are saying that you resolved that case, but at some point, that may not be true for in front of some other judge. They may not have no information, you may be getting held on a case that you may have resolved, right? So you may want to track down that paperwork if you are, when you get out, so you can have that in your possession to show proof that the case was resolved.
Yes, sir.
All right, have a good day, sir. All right. This is. Hello.
Hello?
Hello, good afternoon. Can you tell me your name or give me your ID number?
Yes, my name is Desiree, Desiree. ID 376273.
All right. Could you raise your right hand to be sworn in?
Yes,
Do you solemnly swear or affirm you'll translate from Haitian Creole to English and English to Haitian Creole to the best of your ability, so help you God?
yes, I will.
Ma'am, I need your help with two defendants. I have one at the podium right now. Her case number is 2021 CF 15599 AO. And could you greet her this afternoon and ask her to tell me her name?
OK. Bonsoir, non moi c'est Désiré. C'est moi qui pral interprète créole aujourd'hui. Appel ça qu'à contrôler pour formation à prison. Qualité assurance. Est-ce qu'on peut ba mon nom, s'il vous plaît?
Joris Richard.
Ou ka parler plus fort?
Joris Richard.
Ou ka épelel?
G-E-R-I-S-E. Richard. R-I-C-H-E-R.
The first name would be G-E-R-I-S-E, Joris.
Yes.
And the last name, Richard?
Yes.
Or I-C-H-E-R?
Yes.
Ma'am, you're here in case 2021 CF 15621 AO on a warrant signed by a judge finding probable cause for robbery with a firearm and conspiracy to commit an extortion.
1 second for the interpreter, please, Your Honor. Et Madame Oula Jodian pour cas 2021 CF 156 21 en haut parce que devant juge là pour parce que ou t'as volé avec 11 âmes ou t'es fait une extorsion.
No, but
Sir, ma'am, I'm going to appoint the public defender to represent you in this case.
Il pas fait défendant public là représenter dans cas ça.
I'm going to ask the state of Florida what they want me to do is to count one because it's a punishable by life offense.
Your Honor, as it is punishable by life,
wait,
the
hold on.
state asks.
Excuse the interpreter, Your Honor. Would
Yeah,
you mind
this-
repeating the statement, please?
I said, I'm going to ask the state of Florida what they want me to do with your bond conditions as state count one is a punishable by life offense.
Condition. Thank you. Li t'a demandé, et à la Floride là, qui ça que yo voulez que li fait avec bon nan et pour condition yo?
There you go.
As the case is punishable by life, the state asks defendant be held no bond.
Did we lose you, Madam Interpreter? Madam Interpreter, did you
I am
recuse
sure,
yourself?
Your Honor.
There we go.
Yes? Mm-hmm.
All right. Ms. George, do you have a response to the state's request that the defendant be held at no bond?
Ou répondre et demande non que pas gain aucun bon.
Your Honor, I was also I can't see the facts of this case, but, and I'm just going based off of her history.
Excuse the interpreter, Your Honor. If it's for me, I cannot hear well. It's very far.
Yeah, you may have
Sorry. I can't see the facts. However, based on her history, I would ask that you use your discretion to set a bond if you're inclined to, Your Honor.
Madam Interpreter, you got that?
One second,
Okay.
please. Thank you. Thank you. Et par rapport à histoire là, et j'ai demandé discrétion et pour bonne nan, pas gain fact, beaucoup gain fait.
Well, I'm not sure what happened at the facts of this case as well, which gives me kind of less ability to feel comfortable setting bond in count one. So I'm going to set bond in count one and no bond, and count two, going to set bond in amount of $25,000.
Excuse the interpreter, Your Honor, just for better rendition. You said not sure what will happen. Is that correct?
Yeah, I don't know what happened as far as the facts of this case, because I don't have the warrant affidavit in this case, but I want to set her bond in count one in amount of no bond.
Thank you. Moi pas connais qui va passer exactement avec cas ça, mais moi vais faire affidavit là et mettez bon nom pour une quantité de $25,000.
I'm going to set bond in count two in the amount of $25,000.
Bon pour compte numéro 2 pour $25,000.
Conditions of your bond that you have no contact with your co-defendants in this case.
Sous pas de contact avec défendant dans cas ça.
You have no contact with the victim in this case.
Pas de contact avec victime dans cas ça.
You not return to the scene where this incident occurred.
Ou pas de retourner sous scène côté incident est passé.
You may not possess any weapons or firearms. Any weapons or firearms you have need to be turned over to law enforcement within 24 hours of your release.
Excuse the interpreter, Your Honor. Would you mind repeating the last statement, please?
You may not possess any weapons or firearms. Any weapons or firearms need to be turned over to law enforcement within 24 hours of her release.
Thank you so much. Et ou pas droit posséder armes et faut que retourner dans mes officiers yo et après 24 heures que yo la yo.
You have a great day, ma'am.
Okay, thank you, guys.
All right. What happened to Miss Sam?
Qui s'est passé avec ma femme?
What's the booking number?
210285525.
Bonded.
All right. All right, Madam Interpreter, thank you for your help this afternoon.
You're welcome, Your Honor. Have a good day.
All right, you too.
Thank you. Thank you for using our services.
Good afternoon, man. Can you tell me your name?
Leah Gould.
Ma'am, we're here in case 2021 MM 8148W on charges of petty theft. They reviewed the charging affidavit in your case, did find probable cause for your arrest. We're gonna set your bond in this case in amount of $500. Condition of your bond that you have no contact with any victims or witnesses, and not return to the scene of the location where this incident occurred. Seems that you're out on bond in Osceola County, case 2021 CF 2942, as well as 2021 MM 3017. Court find probable cause to commit new law offenses while you're out on bond. In those cases, going to revoke those bonds. Set new bond at $0. Going to appoint the public defender to represent you in any case that you're not already represented. You have a great day, ma'am.
Your Honor,
Yes,
there's a
ma'am.
co-defendant, and I would ask she have no contact with the co-defendant.
All right. And in condition, also, your bond, no contact with your co-defendant in this case.
Thank you.
Good afternoon, ma'am. Can you tell me your name?
Allison Holden.
Ms. Holden, you're here in case 2021 MM 8678 AO on charge of trespass on property after warning. Did review the charging affidavit in your case. Did find probable cause for your arrest. Unless the state of Florida, we have an offer to resolve your case today.
Adjudication of guilt, credit time served, no return to 4539 Wheelhouse Court.
I got a question.
Ms. Holden.
Your Honor, that's the only place I have to live. If I can't return there, then where do I go?
I'm not sure, but it seems that you may
Because
have
my
a
boyfriend's
trespass.
living there.
You may have a trespass in place that may prevent you from living at that
No, but
location.
the whole reason why I fought, no, I'm just gonna say this, the whole reason why I fought it is it's his sister that had the actual trespass warrant,
Okay.
not me. And I wasn't even asked for ID properly by the authorities. You know what I'm saying? I wasn't even properly identified. Just I identify myself in any kind of way.
So do you want to fight it?
Because, I mean, I'll take what I can and I'll fight it if I have to. I don't want to. I'm just saying, like, that's not fair to me, Your Honor. When I wasn't even properly asked to identify myself or given the opportunity to. And here I am, you know, today, just being kicked off property when that's where me and my boyfriend reside, and we're getting ready to move out anyway. The whole family was, including me. 'Cause we were getting
Looks
evicted.
like back,
Huh?
looks like on the 8th.
That's stuff that I.
Wait. You
I didn't
asked me
know.
a question, and I'm trying to answer your question.
I don't remember a lot of stuff because I just.
All right,
don't
listen,
know.
stop. If you ask me a question, I'm trying to answer your question.
Okay.
All right? Looks like on the 8th, somebody trespassed you. Looks like, according to this affidavit, on the 9th, you returned back to the property. They arrested you for that. Now, you can decide to take this offer right now, or you can go to trial.
I'm just saying I'll take what I can today.
All right, but it looks like you have a trespass in place on this
I
location.
don't understand why I'm being trespassed based on her name. If you look at the trespass warrant itself originally, it says Amber Holden. I'm Allison Holden.
It
I wasn't even
says your
given the
name.
proper authority to identify.
I don't have a
myself.
copy of the trespass warning, so I can't
No, I'm saying.
tell you yes or no, but I'm just telling you that
But where I
at
go
some
now,
point,
that's me and my boyfriend reside there. We were getting evicted anyway. The whole family was getting asked to leave the property.
well, that sounds like you can't go back. I'm
But
trying,
what do I do
I'm
to get my
trying,
stuff that is in the house.
I don't know. You gotta you gotta get down to the civil division and try to talk to them about whatever
Can I
property you have.
call Jeff Connors, who's an actual homeowner, because I was the one that had me arrested was Jason Holden, which is the husband of Amber Holden.
That's not even the person that they list as the victim, so I'm not sure who you're referring to.
That is the person I was told that was on my paperwork as the person who had me trespassed was Jason Holden.
Okay,
Who was the husband of Amber Holden, who the trespass warrant was for originally anyway.
all right, ma'am.
That's all I wanted.
I don't know. I'm just telling you what I have in front of me.
I just want to get that out because I feel like, you know, I should have been heard that originally.
Yeah, ma'am. Right now, all I have is the information I have in front of me. If it's true that those facts in this affidavit are correct, that you were the person trespassed on the 8th and returned on the 9th, then a jury should find you guilty of this charge. If there is some reasonable explanation for that may be true or not, that you might not have been the person that was trespassed originally, that sounds like a great defense that you may want to bring up at a trial. But however, right now, my things I need to do that I have power to do is resolve your case, since this is a misdemeanor case, or give you a bond release condition or some kind of release condition, so then you can then go downtown and fight the case. That's really the only two things I can do right now for you.
And I'm just wondering how I'm going to get to my stuff at
I
all.
don't know. I can't answer all. I'm not the arbiter or
I know
decision maker of all things right now. Those are the two things I have power over. So
Ask somebody at the house if,
out of the two things I have power to do, what would you like to do?
I would like to be able to talk to Jeff Connors, who is the actual homeowner of the house.
Okay. Out of the two things I told you I can do, which one do you want to do? Do you want to resolve the
I'll
case?
take this. I was just wondering if that's where I need to go legally next.
I don't know. Like, once again, you're not listening to me. So there's maybe been a problem in the beginning because you're not listening. I have power to do two things. So which of the two you want to resolve the case? So that's the only thing I can do. So if you want to do the two things, one of the two things, that's all I can do. I can't give you advice. I can't tell you what to do as I can give you what's the next steps. I can't do those things. The law gives me two things I can do: give you some kind of release condition or resolve your case, since it's a misdemeanor case. So if you want to resolve your case, you can raise your right hand so I can swear you in. If not, then we can go, I can give you a release condition, you can go downtown and fight it. All right, do you solemnly swear or affirm the testimony you're going to give in this matters the truth, the whole truth, nothing but the truth, so help you God?
I do.
All right, you can put your hand down. All right, ma'am, the charge you're facing, a trespass after warning in case 2021 MM 8678 AO, is a first-degree misdemeanor, punishable up to 1 year in the county jail and a $1,000 fine. Do you understand that?
Yes, sir.
Do you want to enter a plea of guilty or no contest to resolve this case?
Guilty or no contest to resolve it.
Which one? Guilty
No
or?
contest.
All right. Do you understand by entering a plea of no contest, you're going to waive all the rights on the plea form that you're talking about?
Yes, sir.
Say again?
Yes, sir.
All right.
Sorry, I can't hardly talk about it.
That's fine. Are you under the influence of any drugs, alcohol, or medication?
They said I was on ecstasy, which I don't know how I even got it in my system.
All right, right now. No, not
Not right
yesterday or like we're talking about, at this very moment, are you under the
No,
influence of any
sir.
drugs, alcohol, or medication?
No, sir.
Have you now or in the past been diagnosed with a mental health illness?
Now, no, but in the past, I've been diagnosed with a few things.
All right, what were those things you were diagnosed in the
Major
past?
depressive
Okay,
disorder, panic attacks, anxiety, and PTSD.
all right. Do you take any current medications right now for any of those? You don't take any medications?
No. I
Are you suffering from any of the conditions, like those symptoms of those illnesses, other than being inside of a jail?
Other than being inside a jail, no.
All right. Has anybody forced, threatened, or coerced you to enter this plea?
No, sir.
You understand by entering this plea, if you're not a United States citizen, it could subject you to deportation.
Yes, sir.
I did have an opportunity to view your charging affidavit. I did find a factual basis contained in from the purposes of entering your plea. I'll accept your plea of no contest. I'll find your plea is freely and voluntarily entered. I'll adjudicate you guilty of the charge. I'll give you credit for the 1 day that you spent in the Orange County Jail with 1 day credit time served. The court costs and the cost of prosecution in this case are $273. I'll give you 1 year from today's date to pay that money directly to the clerk in full. You have 30 days from today's date to appeal your judgment and sentence in writing. You have a great day, ma'am. Good afternoon, sir. Can you tell me your name? Your name, sir.
Bobby L. Johnson, your third.
Mr. Johnson, you're here in case 2021 MM 8680 AO on a charge of trespassing an occupied structure or conveyance. I did review the charging affidavit in your case. I did find probable cause for your arrest. State you have an offer to resolve this case.
Adjudication of guilt and credit time served.
Mr. Johnson, do you want to accept the state's offer of adjudication of guilt, credit time served?
Yes, sir.
Can you raise your right hand and be sworn in? Do you solemnly swear or affirm the testimony you're going to give in this matter is the truth, the whole truth, nothing but the truth, so help you God?
Yes, sir.
You put your hand down, sir. Sir, the charge you're facing of trespassing an occupied structure or conveyance is a first-degree misdemeanor. The maximum penalties for that are 1 year in the county jail and a $1,000 fine. Do you understand?
Yes, sir.
Do you want to enter a plea of guilty or no contest to resolve this case?
No contest.
You understand by entering a plea of no contest, you're going to waive all the rights outlined on the plea form you just signed.
Yes, sir.
Are you under the influence of any drugs, alcohol, or medication?
No, sir.
Have you now or in the past been diagnosed with a mental health illness?
No, sir.
Has anybody forced, threatened, or coerced you to enter this plea?
No, sir.
You understand by entering this plea, if you're not a United States citizen, it could subject you to deportation from this country.
Yes, sir.
I did have an opportunity to view your charging affidavit. In this case, I did find a factual basis contained therein.
Yes, sir.
I accept the plea of no contest, finds your plea is freely and voluntarily entered. I'll adjudicate you guilty of the charge. I'll give you credit for the 2 days you spent in the Orange County Jail with 2 days credit time served. The court costs and costs of prosecution in this case are $273. I'll give you 1 year from today's date to pay that money directly to the clerk in full. You have 30 days from today's date to appeal your judgment and sentence in writing. You have a great day, sir.
Thank you, sir.
All right. Good afternoon, sir. Can you tell me your name?
My name is Roy Lee Lovett.
Mr. Lovett, you have two matters. The first one, 2021 MO 1446 AO, with a charge of open container. You also have 2021 MM 8671 AO on a charge of providing false information to law enforcement. The city of Orlando, as to your ordinance violation, the offer is a withhold adjudication and guilt and court costs if you want to resolve your case today. I'm going to ask the state what's the offer in the misdemeanor case.
Adjudication of guilt and credit time served.
Right. I guess it's an adjudication of guilt, credit time served in your misdemeanor case. You want to accept either one or both of those offers?
Both of the offers.
All right. Can you raise your right hand and be sworn in? Do you solemnly swear or affirm the testimony you're going to give in this matter is the truth, the whole truth, nothing but the truth, so help you God?
Yes.
All right, you put your hand down. Sir, the charge in 2021 MO 1446 AO is a second-degree misdemeanor. It's punishable up to 60 days in the county jail and a $500 fine. After your misdemeanor case in 2021 MM 8671 AO, providing false information is a first-degree misdemeanor. It's punishable up to 1 year in the county jail and a $1,000 fine. Do you understand that?
Yes, sir.
Do you want to enter a plea of guilty or no contest to each one of these cases?
No contest, sir.
You understand by entering a plea of no contest that you're going to waive all the rights on the plea form in both cases?
Yes, sir.
Are you under the influence of any drugs, alcohol, or medication?
No, sir.
Have you now or in the past been diagnosed with a mental health illness?
No, sir.
Has anybody forced, threatened, or coerced you to enter this plea?
No, sir.
You understand by entering this plea, if you're not a United States citizen, it could subject you to deportation.
Yes, sir.
I did have an opportunity to review the charging affidavit in each one of these cases. Did find a factual basis contained within. I'm going to find your plea in this case of no, or accept your plea of no contest. Find your plea is freely and voluntarily entered in both cases. I'm going to start my sentencing with the city ordinance case 2021 MO 1446 AO on withhold adjudication of guilt. Give you credit for the 2 days you spent in Orange County Jail with 2 days credit time served. The court costs in the case of $223. I want the sentence run concurrent with this sentence I'm about to announce in case 2021 MM 8671 AO. As in that case, I'm going to adjudicate you guilty as to that charge. Give you credit for the 2 days you spent in the Orange County Jail with 2 days credit time served concurrent with 2021 MO 1446 AO. I'm going to, the court costs, the cost of prosecution in that case of $273. I'm going to combine both of these costs for payment. I'm going to give you 3 years from today's date to pay that money directly to the clerk in full. You have 30 days from today's date to appeal your judgment and sentence in writing. You have a great day, sir.
Thank you, sir.
All right. Good afternoon, sir. Can you tell me your name? There you go. Right in front of the microphone. There you go. Good afternoon, sir. Can you tell me your name? What's your name? All right, you gotta put your mask down so you can say your name.
Mask down.
No, yeah, cover your nose and your mouth. There you go. And just tell me your name.
Cleveland.
What's your last name?
Robinson.
All right. Mr. Cleveland Robinson, you're here in case 2021 MM 8669 AO on a charge of trespass on property after warning. All right, they reviewed the charging affidavit in your case. Did find a probable cause for your arrest.
Yes, sir.
I'm going to ask the state if they have an offer to resolve your case this afternoon.
Adjudication of guilt and credit time served.
All right, Mr. Robinson, you want to accept that offer of adjudication of guilt, credit time served in this case?
Yeah.
All right, can you raise your right hand and be sworn in? Do you solemnly swear or affirm the testimony you're going to give in this matter is the truth, the whole truth, nothing but the truth, so help you God?
Yes.
All right, you put your hand down. Sir, the charge you're facing is a first-degree misdemeanor. It's punishable up to 1 year in the county jail and a $1,000 fine is the maximum penalties. You understand? You understand those are the maximum penalties? Of 1 year in the county jail and a $1,000 fine. Yes or no?
Yeah.
All right. Do you want to enter a plea of guilty or no contest to resolve this case?
Contest.
No comment.
Do you understand by entering a plea of no contest, you're going to waive all the rights outlined on the plea form that's in front of you? Are you under the influence of any drugs, alcohol, or medication?
Yes. No.
Have you now or in the past been diagnosed with a mental health illness?
No.
Has anybody forced, threatened, or coerced you into this plea?
No.
Do you understand by entering this plea, if you're not a United States citizen, it could subject you to deportation from this country? I did have an opportunity to review your charging affidavit in this case, did find a factual basis contained therein. Going to accept your plea of no contest, find that your plea is freely and voluntarily entered. Going to adjudicate you guilty to the charge. Give you credit for the 2 days you spent in the Orange County Jail with 2 days credit time served. Court costs and cost of prosecution in this case are $273. Yes, ma'am.
Sorry, I would ask in this particular case that you would consider reducing that to a lien. He's been homeless for a while now.
All right. I reduce that to judgment. Give you 30 days from today's date to appeal your judgment and sentence in writing. You have a great day, sir. Judgment now. We're trying to give you some work over there. We're trying to give you some work.
You can go. Bye. Bye.
Good afternoon, sir. Can you tell me your name?
Jesse Earl Williams.
Mr. Williams, you're here in case 2021 MM 8531 AO on charge of criminal mischief. Judge signed your warrant in this case, found probable cause for your arrest. State your bond at $500. Conditions: no contact with the victim or any witness, no return to the scene of the location, no weapons, no firearms. Any weapons or firearms he has, he can turn over to law enforcement. Weapon. All right, no drugs or alcohol. I'm going to appoint the public defender to represent him. All right, good afternoon, sir. Can you tell me your name? Can you tell me your name?
Byron Moore.
Mr. Moore, you're here in case 2021 MO 1448 AO on charge of disorderly conduct. They reviewed the charging affidavit in your case, did find probable cause for your arrest. The city of Orlando is offering you a withhold of adjudication of guilt and court costs to resolve your case. That's something you want to do today?
I couldn't understand you fully.
Can we get the hearing devices?
Yes, sir.
All right. Can you hear me now?
Turn it down. I I can hear you now.
You hear me now? All right. Mr. Moore, the charge you're facing in case 2021 MO 1448 AO is a charge of disorderly conduct. I did find probable cause for your arrest. The city of Orlando has an offer outstanding of a withhold of adjudication of guilt, credit for the time you spent in the Orange County Jail, and there's court costs in this case. Do you want to accept that offer from the city of Orlando?
Yes, yes, sir.
Can you raise your right hand and be sworn in? Do you solemnly swear or affirm the testimony you're going to give in this matter is the truth, the whole truth, nothing but the truth, so help you God?
Yes.
All right, you put your hand down. Sir, the charge you're facing is a second-degree misdemeanor, punishable up to 60 days in the county jail and a $500 fine. Do you understand? The maximum penalties.
Yes,
60.
sir.
Do you want to enter a plea of guilty or no contest to resolve this case?
No contest.
No contest.
You understand by entering a plea of no contest, you can be waiving all the rights outlined on the plea form that's in front of you.
Yes, sir.
Are you under the influence of any drugs, alcohol, or medication?
No, sir.
Have you now or in the past been diagnosed with a mental health illness?
No, sir.
Has anybody forced, threatened, or coerced you to enter this plea?
No.
You understand by entering this plea, if you're not a United States citizen, it could subject you to deportation from this country.
I,
If you're not a United States citizen, entering of a criminal
I
plea.
am a United States citizen.
I did find a factual basis based on the charging affidavit that's in the court file. Did want to accept your plea of no contest, find your plea is freely and voluntarily entered. Going to withhold adjudication and guilt. Give you credit for the 2 days you spent in the Orange County Jail, 2 days credit time served. Court costs in this case are $223. I'll give you 1 year from today's date to pay that money directly to the clerk in full. You have 30 days from today's date to appeal your judgment and sentence in writing. You have a great day, sir. All right, good afternoon, sir. Can you tell me your name? Good afternoon, sir. Can you tell me your name?
Jeff Waller.
Sir, you're here in case 2021 MO 1449 AO on charge of open container. The city of Orlando is offering you a withhold adjudication of guilt to resolve this case. Is that something you want to do?
Yeah, I just want to play no contest.
All right. Can you raise your right hand and be sworn in? Do you solemnly swear or affirm the testimony you're going to give in this matter is the truth, the whole truth, nothing but the truth, so help you God?
I do.
You put your hand down. Sir, the charge you're facing is a second-degree misdemeanor, punishable up to 60 days in the county jail and a $500 fine. Do you understand?
Yes.
Do you want to enter a plea of guilty or no contest to resolve this case?
Yes.
No contest.
Guilty or no contest?
No contest.
You understand by entering a plea of no contest, you're going to waive all the rights outlined on the plea form in front of you.
Yes.
Are you under influence of any drugs, alcohol, or medication?
No.
Has anybody forced, threatened, or coerced you into this plea?
No.
You understand by entering this plea, if you're not a United States citizen, it could subject you to deportation.
No.
Have you now or in the past been diagnosed with a mental health illness?
No.
I did have an opportunity to review a charging affidavit in this case, did find a factual basis contained therein. Going to accept your plea of no contest, find your plea is freely and voluntarily entered. Going to withhold adjudication of guilt. Give you credit for the 2 days you spent in the Orange County Jail with 2 days credit time served. Court costs in this case are $223. Going to give you 1 year from today's date to pay that money directly to the clerk in full. You have 30 days from today's date to appeal your judgment and sentence in writing. You have a great day, sir. Good afternoon, sir. Can you tell me your name?
Keith Lamar Harris.
The Harris, you're here in case 2021 CT 2707 AO on a failure to appear warrant. Bond is $2,000. Bond's going to remain set unless you guys have an offer.
No offer.
All right. Have a great day, sir.
Your Honor, I already served time.
Yeah. According to this, you failed to appear at your non-jury trial, so.
Okay, I was incarcerated. That's why I did.
Yeah, that's something you gotta take up with your judge to sign the warrant.
You still have to deal with it in front of that judge.
All right, you got pretrial dates for him?
The Division 81 pretrial conference, January 14th at 9 a.m. in Fort E.
All right, have a great day, sir.
You're gonna have to wait to deal with it.
All right, Gathering, sir, can you tell me your name? What's your name?
Pedro Nota.
Sir, you're here in case 2021 CT 8043 AL on charge of no valid driver's license. I did review the charging affidavit in this case, did find probable cause for your arrest. Was an offer to resolve this case?
Withhold of adjudication and credit time served.
And Your Honor, he does not have any criminal history. And I know they have the new driving program. I would ask in this case, for ROR, it looks like he's been in the Orlando area for over a year. He has no other convictions. He's currently a U.S. citizen, I checked, so I would just ask for an ROR in this case.
All right, sir, are you saying it is Americana Boulevard address?
Yes, sir.
All right. Did you want me to appoint the public defender to represent you?
Yes, yes.
Yes.
All right, sir, I'll appoint the public defender to represent you in this case. I'll release you on your own recognizance in this case. Conditions of your release that you can't operate a motor vehicle without a valid driver's license. So you gotta get down to the DMV, get that figured out before you drive, okay? All right, have a great day. Good afternoon, sir. Can you tell me your name?
Lonnie Joe Tomlin, sir.
What happened to Rogers?
Sir?
He bonded, Your Honor.
All right. All right, I have Mr. Tomlin.
Yes, ma'am.
All right.
I mean, sir, sorry.
No problem, no problem. So you're here in 2021 CT 3635 AO on a failure to appear warrant. Bond in this case is $500. The state has an offer to resolve this case.
Adjudication of guilt and credit time served.
I looked it up. And resolve it.
Did you want to accept that offer today from the state of Florida? Can you raise your right hand and be sworn in? Do you solemnly swear or affirm the testimony you're going to give in this matter is the truth, the whole truth, nothing but the truth, so help you God? Sir, you're here in on this case, 2021 CT 3635 AO on charge of no motor vehicle registration. That's a second-degree misdemeanor, punishable to 60 days in the county jail and a $500 fine. Ms. George, what plea do you want to enter on behalf of Mr. Tomlin?
No contest, Your Honor.
Mr. Tomlin, you understand by entering a plea of no contest in this case, you're going to be waiving all the rights outlined on the plea form that's in front of you.
Yes, sir.
Are you under the influence of any drugs, alcohol, medication?
Medication for my heart.
All right. Does that medication affect the way you think and understand the world around you? All right. Have you now or in the past been diagnosed with a mental health illness?
Yes, sir.
What was that mental health illness?
Bipolar and depression.
All right. Are you taking medications for that? Are those medications helping you?
Yes.
All right. Are you suffering from any of the symptoms of your bipolar depression right now?
The anxiety and,
Well, outside of
stress. Yes.
Stress from being inside of a jail. Anything like, extreme manic conditions, you feel like you're going down into the dump right now?
No, sir.
All right. Has anybody forced, threatened, or coerced you in this plea? You understand by entering this plea, if you're not a United States citizen, could subject you to deportation from this country.
Yes, sir.
Did the party stipulate to a factual basis?
Yes, Your Honor.
Yes, Your Honor.
All right. I did have the opportunity to view your court file in this case. I did find a factual basis contained therein. Going to accept your plea of no contest in this matter. Find your plea is freely and voluntarily entered. I'm going to adjudicate you guilty of the charge, give you credit for the 2 days you spent in the Orange County Jail with 2 days credit time served. Court costs and cost of prosecution in this case are $306. There's also a $50 public defender application fee and a $50 public defender lien. I want to combine all these costs for payment I want to give you 2 years, well, it's actually 3 years from today's date to pay that money directly to the clerk in full. You have 30 days from today's date to appeal your judgment and sentence in writing. You have a great day, sir.
Thank you.
Coke, no sugar? Am I the only one that drink? About one a week. Good afternoon, sir. Can you tell me your name?
Jeremy Anderson.
Mr. Anderson, you're here in case 2021 CF 15600AO on charge of burglary and structure of resisting officer without violence. View the charging affidavit in this case did find probable cause for your arrest. Is this where he qualifies for pretrial release?
It's at your discretion, Your Honor.
All right, now it's gonna set bond in this case. It's gonna set bond count one, $3,500, count two, $100. Condition of bond that you not return to the scene of the location, have no contact with any victims or witnesses, may not possess any weapons or firearms. Any weapons or firearms you have need to be turned over to law enforcement within 24 hours of your release. You're not allowed to possess or consume any drugs or alcohol without a valid prescription. I want to appoint the public defender to represent you in this matter. You have a great day, sir.
Your Honor, this is also a Code case.
Yeah, I'm sorry, no co-defendants. I should have brought everybody up here. No co-defendants, no contact with your co-defendant, which I believe one of them is Miss Bixman behind you. There was one other person, right? And Burke is, no, go ahead, sir. And Burke, this was back to back. It was Bixman, Burke, and Anderson, right? Mr. Burke is also a co-defendant of Ms. Bixman, correct? If I remember correctly.
Co-defendant in that case is, no, it's not the same one, right?
Let me pull it up again. All right. Yep, I had Courtney Burke and I had yep, Miss Bixman. We had one other person. Yeah, I think one other person. Hold on.
Sean Venata.
Yeah.
The other one, and Courtney Burke. Courtney Burke, Sean Venata, and Christina Bixman.
Okay. I'll try to see if you can. At least get Mr. Burke in, Mr. Burke in here. And I'm not sure we can fit Sean Venata. What's her name? Is this Venata? Yep.
Can't see out of this side.
right. I'll go from my left to my right. Ma'am, can you tell me your name?
Christina Bixman.
Ms. Bixon, you're here in case 2021 CF 15571 AO on charge of burglary, conveyance, burglary of structure, and criminal mischief. All right, sir, tell me your name.
Courtney Burke.
Mr. Burke, you're here in case 2021 CF 15572 AO on those same charges, burglary of conveyance, burglary of structure, and criminal mischief. And sir, tell me your name.
Sean Vanetta.
Mr. Venata, you're here in case 2021 CF 15570 AO on charge of criminal mischief, burglary of a dwelling, and burglary of a structure. Review the charging affidavit in your cases. I did find, which is probably the same affidavit, did find probable cause for your arrest in each one of your cases. As to Ms. Bixon and Mr. Burke, your bond condition is going to be the same. Count one, $3,500. Count two, $1,000 and $100 as the count three. As to Mr. Valentina, as the count one, set your bond at $100. Count two, $5,000, and count three in the amount of $150. Conditions are the same in both cases. No return to the scene of the location. No contact with any victims or witnesses. No contact with any co-defendants, which is the three of you in this case. You also may not possess any weapons or firearms. Weapons or firearms you have need to be turned over to law enforcement within 24 hours of your release. You're not to possess or consume any drugs or alcohol without a valid prescription. Give me 1 second.
Your Honor, you said 5,000, I missed the last two because I was writing.
150, Mr. Valentina. Valentina, yep. Yep, 100, 5,000, 150. Yep. All right. Going to appoint the public defender to represent you all. However, one of you is going to get regional conflict counsel. The other one's going to probably get appointed counsel. So you all have different attorneys, so you can have independent representation in these cases. You all have a great day.
Your Honor, you said they were keep separate?
Yes.
I love you.
No, Mr. What's his name was Anderson was a different guy. I remember now. His co-defendant was. His co-defendant was somewhere in the back. All right. All right. Good afternoon, sir. Can you tell me your name?
Anthony Joseph Calabro.
Calabro, you're here in three matters. The first one, 2021 CF 15580, and 2021 CF 15549. Both of those are warrant cases. Both of those have the same charge, burglary or conveyance. Judge already found probable cause for that. Except in 15549, you also being charged with petty theft with two prior theft conviction as well. Judge found probable cause for that charge as well. Bond in 15580 is $5,000. Bond in 15549 is $2,500 and $150 as the count two. You also have 2021 CF 15579 AO, where judge found probable cause for charge of burglary of a structure and grand theft. Bond in count one is $5,000. Bond in count two is $150. Conditions of the bond in all three cases are the same. No contact with any victims, witnesses, or co-defendants. No return to the scene of locations where instances occurred. You also may not possess any weapons or firearms. The weapons or firearms you have need to be turned over to law enforcement within 24 hours of your release. And I want to appoint the public defender to represent you in all of these cases. You have a great day, sir.
Thank you.
Good afternoon, sir. Can you tell me your name?
Frank Michon Castellanos.
Sir, you're here in case 2021 CF 15589 AO on a charge of burglary of conveyance with assaulted battery in and felony battery. Judge signed your warrant. In this case, has found probable cause for your arrest. Give me 1 second. Ms. Castellano, I'm going to appoint the public defender to represent you in this case. And I'm going to ask the state of Florida, what do you want me to do is to count one of the charging affidavit. I mean, the warrant affidavit, I apologize.
Your Honor, count one is punishable by life. I ask defendant be held no bond.
Your Honor, I would ask that, based on the fact that he only has community ties, he lives in the area for over a year, I would ask
May have, besides this is caught on video, seems apparently. All right, Mr. Castellano, is count one, I'm gonna hold you at no bond as to that charge. Count two, gonna set your bond amount of $1,500. Condition of your bond is that you have no contact with the victim or any witness in this case. Now return to the scene of the location where this incident occurred. May not possess any weapons or firearms. The weapons or firearms you have need to be turned over to law enforcement within 24 hours of your release. Now you're appointed the public defender to represent you in this case. You have a great day, sir. Good afternoon, sir. Can you tell me your name?
Christopher Michael Cooper.
Mr. Cooper, you're here in case 2021 CF 15264 AO on a charge of solicitation to commit a sexual activity with a child. Judge signed your warrant in this case has already found probable cause for your arrest. We're going to appoint the public defender to represent you in this case. Got a chance to talk to Mr. Cooper. 1 second. I don't believe this is a life offense or punishable life offense, correct?
No, Your Honor, it's a second
I think
degree.
it's like a secondary felony. All right, sir, I'm going to set your bond in this case amount $30,000. Condition of your bond is that you have no contact with his victim or his victim's family. You don't have no contact with any witnesses from this case. You may not return to the scene of the incident where this incident occurred. You also may not possess any weapons or firearms. The weapons or firearms you have need to be turned over to law enforcement within 24 hours of your release. You also may not have any unsupervised contact with any child under the age of 18 years old. Want to appoint the public defender, already appointed the public defender to represent you in this case. You have a great day, sir.
Your Honor, my client can afford a $30,000 bond, and we're trying to reduce that bond amount.
Not based on his criminal history.
Thank you.
Good afternoon, sir. Can you tell me your name?
David Cordero, sir.
Mr. Cordero, you're here in case 2021 CF 15536 AO on charge of sex offender, failure to register. Did review, the judge signed your warrant, did find probable cause for your arrest. Going to set your bond $3,500. Condition of the bond that you have 48 hours to report to the sheriff's office as a violent sexual predator or sexual offender.
But he does.
I'm going to appoint the public defender to represent you in this case.
No, that was
Ms. Davis is telling me
I
no.
was like,
Ms. Davis told me, she's shaking my head no. She told,
okay.
before we started, she was telling me no, so. That was it. I did.
Your Honor, Anthony Dominguez is medical.
All right, it's 2021 CF 15604 and 2021 CF 15605. I'm going to appoint the public defender to represent Mr. Dominguez.
I'll wait here, sir.
All right, and this trafficking case, probable cause determined. Bond's $50,000. Condition of bond, no drugs, alcohol without valid prescription. Subject to Florida Statute 903.046, sub 2, sub A, need to file an affidavit with the court attesting that the funds used to bond him out did not come from an illegal or illicit source. In 2021 CF 15605 AO, probable cause determined, count 1 and 2, bond $3,500 in count 1, $100 in count 2. Addition to bond, no return to the scene, no contact with any victims or witnesses.
Your Honor, this is a Code D case. I don't think,
There's no contact with any co-defendants in this case. Either case, in both cases. Yes. And Dunlap.
Dunlap bonded out, Your Honor.
Wonderful. All right. Fisher? Good morning, ma'am. Sorry, good afternoon, ma'am. Can you tell me your name?
Genesis Fisher.
Ms. Fisher, you're here in case 2021 CF 15588 AO on a charge of carjacking. Judge signed your warrant. In this case, did find probable cause for your arrest. Going to say that your amount of the bond on the warrant, $10,000. Condition of bond, no contact with any co-defendants, no contact with any victims or witnesses from this carjacking, not possess any weapons or firearms. Any weapons or firearms you have need to be turned over to law enforcement within 24 hours of your release. And I want to appoint the public defender to represent you in this case. Seems that you're out on bond in case 2021 CF 13482 AO. Court find probable cause that you commit a new law offense while you're out on bond. In that case, you're gonna revoke that bond. Gonna set a new bond at $0. Still conditions you have no contact with any victims or witnesses from that case, even from the jail. Mr. Foster is Mr. Allen's the co-defendant. All right. Got the sir, can you tell me your name?
Is Edward Foster?
Mr. Foster, you're here in case 2021 CF 15569 AO on a charge of burglary of a dwelling and petty theft of $100 or more. Reviewed the charging affidavit in this case, did find probable cause for your arrest. Count one, $5,000. Count two, $100. Conditional your bond that you have no contact with your victims or witnesses. Now return to the scene, the location where the incident occurred. You may not possess any weapons or firearms. Any weapons or firearms you have need to be returned to law enforcement within 24 hours of your release. And you also not possess or consume any drugs or alcohol without a valid prescription.
Call that number.
Appointing the public defender to represent you. You have a great day, sir. Good afternoon, sir. Can you tell me your name?
Brent Levine Gaines, sir.
Mr. Gaines, you're here in case 2021 CF 657 AO on a failure to appear warrant. But judge signing your warrant in that case, set your bond at no bond. Your bonds can remain at no bond. I believe you already have the public defender. You have the public defender representing you already in this case. You have a great day, sir. All right, it's 2021 CF 15610 AO. Going to appoint the public defender to represent Mr. Galazzo. All right. I'm going, the court probable cause determined for trafficking amphetamines of 28 grams or more. Going to set bond in his case amount of $200,000. Condition on his bond that he not possess or consume any drugs, alcohol without a valid prescription. He also be subject to Florida Statute 903 sub 903.046 sub 2 sub F, and file an affidavit with the court attesting that his funds used to bond him out did not come from an illegal or illicit source. All right, got the news, sir? Can you tell me your name?
Katie and Grant.
Mr. Grant, you're here in case 2021 CF 1953 AO on a failure to appear warrant. Bond in that case is no bond. Bonds remain no bond. You have a great day, sir.
All right.
Yeah, are you taking action to this misdemeanor case? Good afternoon, sir. Can you tell me your name?
Lamarius Jones.
Mr. Jones, you're here for two matters. The first one being 2021 CF 6408 AO on failure to appear warrant. Bond is $3,000. You're also arrested in 2021 MM 8676 AO on charge of possession of cannabis. Did review the charging affidavit. The case did find probable cause for your arrest. Stating bond $500. Condition your bond, no drugs or alcohol without a valid prescription. Subject to random drug and alcohol testing. Yep, in the new case, correct. Appoint the public defender to represent you. You have a great day, sir. All right, good afternoon, sir. Can you tell me your name? All right, got to slide in front of the microphone for me. There you go. Tell me your name one more time. Mr. Keenan, you're here in case 2020 CF 14808 BO on a charge of human trafficking in count one, unlawful use of two-way communication device in count two, and deriving support from the proceedings of prostitution in count three. Judge signing a warrant in this case and probable causes either determined by reviewing those affidavits. In that case, did find there's probable cause for your arrest. State, what are you asking I do is to count one of Sorry, Ms. Keenan, I want to appoint a public defender to represent you in this case, but I think you're going to get another attorney soon after this. But say what you're asking I do is to count one.
Your Honor, as that is punishable by life, I ask defendant be held no bond.
And Ms. George, for the purpose of this hearing, what is your response? Mr. Keenan, as to count one, was a life offense, going to hold you at no bond, going to stay your bonds and your other counts at $5,000 and $15,000 apiece. That you have no contact with your victims from this case, no contact with any witnesses, no contact with any co-defendants from this case. You may not possess, consume any drugs or alcohol without a valid prescription. You also may not possess any weapons or firearms. The weapons or firearms you have need to be returned to law enforcement within 24 hours of your release. You have a great day, sir.
Your Honor?
Yes, ma'am.
Can we also make it a condition that he have no unsupervised contact with
All
any
right,
minors?
Mr. Keenan, I want to make it a condition you have no unsupervised contact with a child under the age of 18 years old.
Your Honor, Lang, recused.
All right, it's 2021 CF 15615AO, Mr. Lang. I'm going to appoint a public defender to represent him.
I'll waive the appearance, Your Honor.
All right, probable cause has been determined as to counts 1 and 2, bond count 1, 1,000, bond count 2, 100. No drugs or alcohol without a valid prescription, random drug testing. He's out on bond in 2021 CT 7866, as well as 2021 CF 15276. Court is going to revoke those bonds, set new bond at 0. I don't believe so. I'll appoint a public defender to represent him in case he's not already appointed. All right, Gathering, sir, can you tell me your name?
Christopher Lentz.
Mr. Lindsay, here in case 2021 CF 15608AO on a charge of dealing in stolen property, grand theft, possession of burglary tools, resisting officer without violence, and possession of drug paraphernalia. I did review the charging affidavit in your case, did find probable cause for your arrest. Count 1, $2,500, count 2, $150, count 3, $150, count 4, $100, and count 5, $100. Condition of the bond, no drugs or alcohol without a valid prescription, random drug testing. You also may not have any contact with any victims or witnesses from this case. I'm going to appoint the public defender to represent you. You have a great day, sir.
All right, yes, sir.
Good afternoon, ma'am. Can you tell me your name?
Yes, Mitchell.
Ms. Mitchum, you're here in two matters. The first one, 2021 CF 15596AO on charge of petty theft with 2 prior theft convictions. You're also here in case 2021 CF 15596AO on charge of grand theft. Give me 1 second.
Oh, what happened to miss him? Thank you.
I did review the charging affidavit in this case, did find probable cause for your arrest. Going to set bond in both cases the same, $1,500 on each case. Condition of bond, no return to the scene of the location, no contact with any victims or witnesses or any possible co-defendants. I'm going to appoint the public defender to represent you in both cases. You have a great day, ma'am.
You too.
Yep.
Gina Marie McGovernshuk is medical.
All right, 2021 CF 4035AO, I believe she already has a public defender.
I'll waive the appearance.
All right, bond in her failure to appear warrant $1,500 on count 1, $200 on count 2. Kathleen, sir, can you tell me your name?
Junior Paul.
Mr. Paul, here in case 2021 CF 14039AO on charge of aggravated battery, alternative, false imprisonment, and battery domestic violence. Did anybody contact this victim?
Not that I'm aware of, Your Honor.
It's a DV case, really, but
No victim contact information provided.
And they didn't, the law enforcement officer didn't mark it, to our knowledge, as domestic, so we didn't have any victim information.
okay. So it's my understanding, but these cases aren't reviewed by facts, they're just reviewed by the charges when they come in through the system.
I mean, usually like on the affidavit, the law enforcement officer is supposed to mark if it's DV or not.
Uh-huh.
And in this case, it didn't, so it didn't transmit through our system as domestic. And he didn't provide us with any victim card, notification card, or information or anything.
Okay. All right, Mr. Paul, it's account one, I'm gonna set your bond in this case an amount of $25,000. Count two, 150, count three, 100. Condition on the bond that you have no contact with any victims or witnesses no contact with the victim. You maintain a separate residence from the victim. One-time return with law enforcement to retrieve any personal items you have at that location. You may not possess any weapons or firearms, and weapons or firearms you have need to be turned over to law enforcement within 24 hours of your release. And want to appoint the public defender to represent you in this case.
Your Honor, on count one, did you say 25,000?
Yes, ma'am.
I would ask that you consider reducing, I don't see any type of criminal history, on count one. I would at least ask that you reduce to 10,000, Your Honor.
Go back to reading
He
this
hasn't been
affidavit
convicted
again.
of any violent offense.
I think I signed this warrant, so let me,
Oh,
no, so wait, let me go back. I said, no, I didn't sign this one. This was a one, all right, I was reading the probable cause supporting affidavit, that's what I was doing. All right, no drugs, alcohol without a valid prescription. Yeah, not based on, I remember reading these, I was reading these facts over the break, not based on the facts in this case. Yeah, no contact with the victim, definitely that, yeah. Definitely up there. Good afternoon, sir. Can you tell me your name?
Abdul Powell.
So, Powell, you here in case 2021 CF 15609 AO on charge of possession of cocaine and possession of cocaine with intent to sell and deliver. View the charging affidavit in your case. Did find probable cause for your arrest. Bond in count one, $150. Count two, $7,500.
I'm sorry, I did have a probable cause.
All right, go ahead.
Your Honor, I would argue that there is no PC to the possession with intent to sell or deliver. I know they found the 3.5 grams of cocaine, but they also found paraphernalia. I believe it was a syringe that would indicate that they were using it for personal use as opposed to intent to sell or deliver. There's no scale that was located. There's no huge amounts of cash there isn't any indication in the four corners of this arrest affidavit that Mr. Powell would have the cocaine with the intent to sell or deliver, other than having the cocaine on him. It just says, please see further details for a report. I would just argue there's not enough here in this arrest affidavit.
All right, State.
Your Honor, if you would give the state 24 hours, as Ms. George indicated, beside the intent to sell, it does say see Officer Kerr report. Unfortunately, Officer Kerr's report was not included. So I would just ask for the 24 hours to see if I can obtain that report.
All right, so I will give the state the 24 hours and count two. You still do not want me to set bond in this case?
I do want you to set bond, Your Honor.
All right, so I set bond at $7,500, count two. Pretrial release. Actually, no pretrial release, just no drugs or alcohol without valid prescription, no contact with any co-defendants, random drug testing.
Your Honor, you just said pretrial release for both or just one?
No, I said no pretrial release. I just gave him bond.
Okay, and you said 7,500
And count two.
and count one.
150.
It was 1,000.
Yeah, reset in 24 hours for a state determined probable causes to count two.
I'm sorry. I apologize, Your Honor. Can you go over the amounts and the conditions again? I apologize.
It says 150 count one, $7,500 to count two. Reset and count two for tomorrow for pre-trial, PC determination. No drugs, alcohol, random drug testing.
Thank you, Your Honor.
But bond conditions can change in count one if PC is not found, in count two by Judge Gibson.
How much is my bond?
Good afternoon, sir. Can you tell me your name?
Andre Ruiz, sir.
Sir, you're here in case 2021 CF 15607AO on charge of possession of a concealed weapon by a convicted felon.
Your Honor, I would ask for pretrial release. In this case, he does qualify.
Let me look at something. There was something I need to look at real quick, I remember. All right, sir, I'll release you on pretrial release in this case. Condition of your pretrial release, not allowed to possess any weapons or firearms. Weapons or firearms you have need to be turned over to law enforcement within 24 hours of your release. Also not possessing any drugs or alcohol without a valid prescription. I'm appointed the public defender to represent you. You have a great day.
Thank you, Your Honor. Have a blessed holiday.
My own. See that one. That's it.
Welcome to an Acano meeting. You are entering the meeting now. You are the only participant.
Good afternoon, sir. Can you tell me your name?
Christian Jose Santana Gregory.
Mr. Santana Gregory, you're here in 2020 CF 12088AO on a failure to appear warrant. Bond in your warrant is no bond. Bond's going to remain as set. Looks like you already have an attorney representing you in this case. You have a great day, sir.
Excuse me?
Look, you already have an attorney representing you?
Well, I believe I do. His name is Gary Schwartz.
Yes.
I do want to ask, if I may, how old is this warrant? Because I have been incarcerated since April.
I don't know. Let's find out. Looks like the warrant was issued back in June. So I don't know where you were or where.
Seminole County, with another charge over there that I.
Were you in contact with Mr. Schwartz? Did he know where you were?
No, I did not I don't even know him. I have never spoken to him.
All right. Do you have his information now?
Well, they just gave me his name right now.
Do you have his like name, his number? That's what I'm
No,
asking.
I do not.
Can we print the notice of appearance in line 13? All right. Have a good day, sir.
All right, thank you. You too, sir.
All right. Story. 2019 CF 1450AO, going to appoint the public defender to represent. Mr. Story. Ms. Story.
I'll waive the appearance, Your Honor.
All right. Bond heard and failure to appear warrant is no bond. And Turdell.